Mentioning.
Yes, my lord. My lord remembers this matter, my lord, for settlement between the official receiver and with the Shebayats of some properties, my lord. My lord, it has been settled between the parties. My lord, the official receiver is represented. My lord, I have been asked to file an affidavit stating therein that you should not give any liability to the official receiver, and official receiver on as is where is whatever there is will hand over the properties to you. So that
For
affidavit
inclusion
has
in the
been,
list.
for settlement.
No, for inclusion in the list.
Yes, but my lord, the matter was running. My lord, thereafter fixed this matter on 27th of September. My lord asked us if it is settled between the parties, you come and mention it, then I will put it in the list
All
for
right.
settlement. Well, this is
Tomorrow.
number 4.
Tomorrow or after a couple of days.
No. It's ready, my lord. They have
If it
already
is
approved.
ready.
Yes.
So better. I mean, I'm keeping it on Tuesday.
Tuesday, my lord. Please, your lordship. Grateful.
5th September.
Origin side, commercial division for arguments. Item number 1, Messrs. A.K. Ghosh and Sons.
Yes.
Well, the plaintiff, I believe, has finished. I was not there on the last occasion.
Mr.
I
Mitro.
believe
Yes,
Mr.
Lordship.
Mitro
Mr.
has-
Mitro has ended his submissions. Lordship had directed us to file a written notes of argument, but Lordship, due to some personal difficulty, I couldn't complete it. So I'm seeking a short. However, Mr. Ghosh can.
I have given you my notes.
Yeah, we've received your.
I gave them, they made, so I want to see what
How long
they
will
have
it take?
submitted.
3 days, 4 days?
Lordship, a week. Lordship.
1 week.
Yes, Lordship.
Well, let them share. I have given them my
Yes,
notes.
Lordship. We'll forward.
Then I can deal.
Counsel appearing for the
চারটে কেস দেখিয়েছো দিয়েছে আমার
plaintiff.
তোমরা 5টা কেস দেখিয়েছো
Plaintiff craves leave to file written notes of argument within a week.
except for 13th and 14th on any other. Those 2 days I'm not.
Did the matter appear in the list on 11th?
Grateful.
Grateful, Lordship.
Let this suit appear in the list on 11th September.
Grateful.
Witness action.
Where is Mr. Ghosh?
Item number 3. Item number 2.
He said last day he said he will file an application.
Number 2.
Your Lordship, I appear for the plaintiff. Your Lordship, kindly fix this adjourn this matter for 2 weeks.
Why?
The plaintiff, we were supposed to file an affidavit,
Yes.
but the plaintiff is not well.
My lord, already 7th, 8th occasion passed by for argument, my lord.
I am
It is a
giving you
matter of-
1 week's time. Otherwise, I will conclude argument. You are too late. An accommodation is sought for on behalf of the plaintiff. The matter is adjourned to 12th September for further argument and filing notes of argument.
My lord, I have already submitted my written notes of argument.
For notes of argument by the plaintiff.
My lord, next date is
12.
12, yes.
Witness action.
Lordship,
Item number 3.
Lordship, I am for the plaintiff. My lord, in the last occasion, my lord, the witness action has been closed, my lord. Now, my lord, the matter has to appear as for arguments, Lordship.
DW was examined.
Yes, everything is
Examine
complete.
and cross-examine completed.
The
Kindly
learned
fix-
counsel of both the counsels for both the parties submitted that witness action is complete. The matter may be fixed for argument. When will you come? At least start argument. Who adduced evidence last?
Their count, their witness was there. My lord, it is a re-examination. My lord, he has called for
That
re-examination.
might be. Basically, re-examination is not examination in fresh. Defendant adduced earlier,
Earlier, my lord,
defendants will start.
dependent evidence was completed 15 years back.
All right. Defendant will start argument. That is the rule. Defendant will start argument. He's not comfortable with starting argument.
Yes.
Lordship will fix a date, Lordship.
Lordship, fix the date, my lord. Mr.
Will come.
Sarkosan is appearing. My lord, he has said, my lord, let plaintiff argued. Already two issues, argument of two issues has been completed earlier.
I've
Well,
heard
however,
a hard argument.
yes,
No.
yes, it is hard.
Initially, there was the matters reached the argument stage, my lord. Thereafter,
Possibly
my lord.
there's some issue of re-examination.
Yes.
Yes.
Thereafter, the witness was
Very correct.
re-examined.
That's why it came in under the heading witness action.
Yes, yes. On the last occasion, the witness have been cross-examined. Last order. No.
Yes, it is noted. Witness action of the suit is over.
Yes.
It is to come on commercial division.
Yes. It's appearing in the commercial division.
Cross-examination was deferred. Cross-examination of PW1 was deferred.
Cross-examination has completed, my lord, last.
No, he was, when it was completed? 15 July, it was deferred to 27 July, then 27.
So, my lord, the cross-examination was completed on 31st July 2023.
Fixing on 6 September.
Not sixth, my lord. Either 7th or, my lord, day after, next week.
11.
Yes.
The suit will appear in the list under heading argument on 11 September.
In the commercial division, Lordship.
Definitely, it has already come in commercial division.
Lordship, one thing, my lord, I have prepared the statement of truth and the list of documents, my lord. I'll be filing it in the department. Or may I file it over here, Lordship? Lordship, I'll file in the department.
Okay.
Right now, my lord, couldn't place the
All right.
10. 11.
4. Oh, file, no?
All suits, item number 4. Steel Authority of India.
None appears. Adjourn to 6 September.
Item number 5.
Your Lordship, in item number 5, I am for the plaintiff. Your Lordship was pleased to transfer the suit to commercial division, Your Lordship. Thereafter, Your Lordship was pleased to direct the matter to go before the mediator. Mediator was appointed. Only 2 references took place before the mediator in the month of April and in the month of May. Thereafter, the mediator could not give his time to conduct the proceeding before the
It's
mediation.
supposed to complete within 2 months.
Your Lordship, that has not been done. Your Lordship, a report has been placed before Your Lordship, I am told. Your Lordship will kindly.
What was the stage of the suit?
The stage of the suit that issues were to be framed, Your Lordship. Discovery was done.
Where is the report? Any report of the mediation?
না রিপোর্ট দিয়েছে যে শেষ হয়নি টাইমের মধ্যে।
Member Secretary of the Mediation and Conciliation Committee.
Lordship, before that, I have a small submission. Lordship. Lordship, in this matter, during pendency of this mediation, as we informed them by letter that we are government company, we don't want to block someone's premises, Lordship. I have initiated all action to leave the premises because under RDI, Regulated Authority of Insurance, I have to give notice to the public. I always cannot all on a sudden shift my. So I have initiated those proceedings. But Lordship has to protect me that I am doing this without prejudice to my right and condition in the suit, so that they will get back their possession. Mean profit claim will be remain against me, but this should not be treated that I have been thrown out or something. Without prejudice to my right and condition, I am taking steps to vacate the premises.
I am only noting that a process of conciliation is going on, apart from mediation.
And also I am taking steps to vacate the premises without prejudice to my right.
Lordship, kindly record that my learned
Yes.
submission is going to.
Yes.
And when
It's a good submission for you. It is going to help you.
your client will vacate the position, that may also be if
Yes, I have
possible.
no.
Submitted a report dated 7/8/2023. Full stop. Let this be kept in record. Full stop. The report shows that in spite of expiry of 60 days, mediation could not be complete. Therefore, mediation is deemed to be failed.
Lordship, in view of that, I am already leaving the premises, only a mean profit. There now the chances will be more.
I will not mention anything, come subsequently. Learned counsel appearing for the defendant fairly submitted that his client is in the process of handing over the possession of the premises without prejudice to any right and interest
In the suit.
in the suit. Full stop. Be that as it may. Full stop. The suit will appear in the list when it can be fixed.
First week of October, Lordship, I can process that part.
5th October,
Lordship, obliged Lordship.
I am fixing it for framing of issues. If it is settled, I will pass order. Issues are framed or not?
No,
No,
Lordship, so far.
issues are not framed.
Lordship, then parties may be directed to place suggested issues on.
No, discovery inspections are complete
Lordship.
for framing of issues. Full stop. Parties are at liberty to mention the matter prior, beforehand, for passing necessary order regarding settlement arrived at, if any.
Lordship. I'm deeply obliged, madam. Deeply.
Oh, sorry. Sorry to be. To be mentioned like as well.
এক নম্বর ধরবে, এক নম্বর ধরবে।
Regular list to be mentioned, item number 1.
I am appearing for the applicant, your lordship.
My lord, I
For
am
the-
the respondent in this matter. Your lordship will recall on the last occasion, the erstwhile advocate on record, my lord. object to the appearance of my advocate on record and mine, your lordship. Therefore, my lord, Mr. Ghaffar is there. My lord, in view of that, my lord, I would request 4 weeks time, your lordship,
No, your
to
lordship.
settle the dispute between whatever discrepancies there between the parties, my lord. I'll make sure that in 4 weeks, no objection is obtained from him, my lord. He's there. My lord,
Issue will be settled. Disputes will be settled.
whatever, not my lord, which
Your
not
lordship
regarding
kindly
the matter,
hears me
my
out.
lord.
Just a minute, I will hear you.
Not regarding with the matter, whatever there, my lord, with my client and his erstwhile advocate on record, my lord. So whatever issue is there, my lord, we haven't obtained the no objection, but we are
2
appearing.
weeks,
in
I'll
that
give you
regard.
2 weeks time, settle it in the
Your
meantime.
lordship kindly does not. Your lordship kindly sees the conduct of the advocate on record and the erstwhile advocate on record of the
No conduct.
respondent,
My
your
lord, is
lordship.
there, my lord.
Your lordship,
Please submit,
these are all
submit.
these are all dilatory tactics to delay the hearing of the matter, your lordship. Your lordship, because there is an issue between the two advocate on records of the respondent, the hearing cannot be stalled for months together.
Change of administrator, that case.
Yes, your lordship. Now,
Administrator
just
is-
to stall the hearing, these are dilatory tactics, your lordship.
This is
Your lordship
yes,
kindly hears me out. Your lordship, it is the incumbent duty of the respondent to sort out this. For these, the advocate on records cannot take weeks before before this honorable court.
No question of 4 weeks.
Your lordship kindly keeps it next week for hearing.
Kindly,
Not
this week, my lord, because
your lordship kindly hears.
my lord,
Your lordship kindly keeps it next week for hearing and direct
defendant.
them to sort it out in the meantime.
You are for
defendant, respondent, your lordship, in the applications.
the learned counsel for the respondent. Praise for adjournment. Although objected to strongly by the learned counsel for the petitioner. Considered the matter is adjourned to 8th September.
Your lordship kindly keeps it for hearing on that date.
My lord,
Possible.
my lord.
8th September, the matter will come in the list on 8th September under heading hearing.
And your
I'm
lordship
giving you
kindly.
accommodation, whether you can do or not, that's up to you.
My lord, 2 weeks time, my lord,
No
kindly.
question, no question. I will continue to hear. Either you submit, either you settle, or I will pass order. Next.
Much obliged.
Very well, my lord.
2 and 3 should be together.
2, 3 and 4. Item 3 and 4.
My lord, in this matter, I am applying for defendant number 4.
Use microphone.
Was completely gone up the order by the department for grant of leave.
My lord, my learned friend is appearing. I do not know for whom.
You are in
Plaintiff number 2 in person.
plaintiff number 2 in person.
Plaintiff number 2 had appeared through a lawyer. I do not know, my lord, how.
I am for plaintiff number 1 and 3. We did not never represented him. He has been contesting independently. So
I am appearing in
What is the
person.
matter about?
matter
This
is
is a
about
partition shoot.
Matter is not.
special officer lordship has directed Mr. Dutt, who was the special officer, to convene a meeting. And that consider the offers coming from different parties who wanted to purchase the property, the partition suit.
What about these applications? GA8, GA10?
GA8 is the application in which lordship on 10th of August will pass this order.
My lord, may I very humbly submit and
Just a
encapsulate
minute.
what is.
GA8 is?
GA8 Milord, is the application by Milord.
Let me have the applications.
The matter was fixed on the 28th
Let me
September.
go through the applications first.
On 28th September, the date is fixed for
First,
hearing.
you should take leave that instead of calling lawyer, you will appear in person.
Yes, my lord.
That is the procedure.
Yes, my lord. And that I believe has not been taken. That's the reason I will raise that objection. My lord, may I?
First take a leave. First take a leave
Yes.
from the department.
Yes.
What you are writing here? Place
again,
before the department will submit a report.
My lord, this matter, your lordship was pleased to fix the matter on 20th was as regards sale. That matter.
Let me go through the applications first and order sheets.
My lord, before we trouble your lordship, my lord, may I very
I will
briefly-
now read, then I will hear.
Lordship, my lord.
Don't interrupt.
My lord.
Let me come this side.
So in GA8, so many prayers are clapped together. Who has filed GA8?
Plaintiff number 2.
Thank you so much. Thank you.
Then GA, exchange of affidavit in respect of GA number 8 is complete.
Yes.
Now GA number 10
The G10 I have filed, my lord. It's filed by defendant number 6B.
for
That's my petition, my lord, for the modification of an interim order of this honorable court. Your lordship was pleased to hear this and fix it on 28th of September. That is reflected, my lord.
an order of injunction.
Yes, my lord. There's an order of injunction, and that, my lord, requires to be varied. If your lordship comes to page 20 of this application, your lordship will find the first prayer being injunction, which was, my lord, passed. This is, my lord, for the notice of sale. Your lordship will kindly note there is an order which we are now praying be modified because a substantial amount has been, my lord, negotiated upon over the months and years. And now, my lord, we want to give up our right against this valuable consideration. Your
Order
lordship will
be
be pleased to-
passed allowing demarcation of 1/24th share of the applicant.
My lord,
Preliminary decree is passed.
it is
Long
long,
back.
long back.
That in fact, all
The
these
preliminary decree was passed in 1992-93, my lord.
all these prayers were considered by a lordship on the last occasion on 10th of August. Lordship was of the view that before this, the land special officer filed the report, and consequent to that, lordship would consider these orders, these prayers.
My lord, there are
No,
talks of
there is another thing to be done, as appears from GA number 8.
The demarcation, the
No, not
inscription.
demarcation. It's not question of demarcation. It's a recording death of 5A and 6A.
That is all one of the prayers, my lord.
I am for 6B.
But first you seek leave to appear yourself personally. You file application.
Yes, my lord.
Otherwise, I won't hear you.
In fact, the learned special officer can act on the on the server copy of this order itself, which is for a meeting.
Just a minute. Let me
Upon the
understand
direction
this thing
given.
first. Then GA number
My lord, GA 12 is where, my lord.
to see unauthorized construction of a suit property. Who is for the receiver?
Mr. Receiver, my lord,
Right.
receiver, Mr. Shuman Dutt is the special officer now, who is to convene a meeting. But that we are at that stage. All these prayers, lordship on the last occasion has said.
My lord, if
that
your
we
lordship
consider it
takes
on
up
the
the
day.
last order of 10th of August,
Kindly,
my lord,
that clarifies the issue.
that clarifies. Well, the last paragraph of page 2.
In fact, my lord, we have also deposited this money.
The receiver is supposed to file a report on 10th August. So let the report come, then I will hear these applications.
Without this report, my lord, of either receiver or special officer, my lord, we cannot make any progress in the suit.
Second thing, this application is filed by
My lord,
plaintiff number 2.
Yes.
You are appearing in person.
Yes.
You have to take leave to appear in person instead of learned lawyer because Wakalatnama is filed.
my lord.
Wakalatnama is there on record. You file an application in the department
Okay.
that you will appear in person. Unless leave is granted to you, I won't hear you.
No, I just ask,
No, go to the
request for
department.
leave to complete the order by the department.
You can't do that.
Complete and drop the order
Which order?
10th August and 20th July. And 13th.
Uh-huh. 10th August আমি তো ছিলাম নাকি 10th August not today হয়েছে
That order is passed in GA8.
The order is passed in GA8, my lord, of 2015, 10th of August.
This order.
It is supposed to appear on 28th September.
Yes, my lord.
So let that appear on 28th
Yes,
September.
Yes, that is. In the meantime, this meeting.
Which
will
order
be-
has to be drawn up? তো কি করতে হবে? কেন লিভ ড্র করা হয়নি কেন?
Because I don't think that with these letters, which is written by the person.
এটাতে লিভ দিও না, ওনাকে আগে অ্যাপিয়ার করতে বলো, রাইট? Let him appear.
Letter should be written by the advocate.
And also, my lord, here in the last order, it is recorded that, my lord, plaintiff number 2 is being represented by an advocate, Mr. Prabir Kumar Das.
Yes.
My lord, he
So
can't
you-
make this submission without, my lord,
No,
appropriate
Prabir
steps.
Kumar Das for plaintiff number 2 in person.
He is for that.
In person. Mr. Prabir Kumar Das appeared in person. Prabir Kumar Das, the plaintiff number 2, appeared in person. Whereas the recorded lawyer did not appear in the suit. Let him appear, let him file necessary application for representing himself in person in order that leave may be granted. Full stop. The matter is already fixed on 28th September 2023. Let the matter appear in the list on that date.
Very deeply obliged, my lord.
Grateful.
First, you will take leave. Second thing, for recording death of defendant number 5A and 6A, you have to file death certificates. What are death certificates? You have to file death certificates with supplementary affidavit. Go and take leave.
Item number 5.
My lord, I am appearing on behalf of the plaintiff.
So I'm appearing for the number 8 and 9.
I am appealing for some of the defendants, 2B3.
What about these pending applications?
My lord, no, my lord can dispose of this application because now the parties have agreed to settle the
Settle the
matter.
matter.
The last GA in which we have filed the terms of settlement, my lord can pass a preliminary decree on the basis of that GA.
Preliminary decree is passed.
No, my
No,
lord,
no, my
that
lord.
is what we are praying for. That is the last GA we have filed. Parties have filed the terms of settlement in which they have agreed to,
Oh, it is that one.
my lord,
The records were not found.
my lord, my lord. It's a 61 suit, my lord. Now the parties are willing to settle it. Let a preliminary decree be passed according to the terms of settlement filed in that GA, my lord.
But nothing has happened in this suit much, my lord. Now the parties have agreed to settle the matter.
Now, after the preliminary decree is passed, we have to appoint partition commissioner.
My lord, there's already a special officer appointed. Will
You are the
I'll-
special officer.
no, my lord.
No, I am for the 8 and 9.
8 and 9. There's already a special officer appointed, my lord. But he was not taking any step. We'll file one more after this decree is passed. We'll file one more application for
Let the
appointing
decree be
the
drawn up, you file application for appointment of partition commissioner.
my lord. And we'll ask for the advocate on record of the
Both the
parties.
parties.
Both the parties.
That will expedite the matter.
My lord.
Yes,
GA number 16 of 23.
yes, my lord. Yes, yes, my lord.
16 of 23. That contains terms of settlement.
No, no.
These are terms of
16 of 23, my lord.
Yes, 16 of 23
My lord.
is filed for passing preliminary decree in terms of settlement contained in the said application. Is it signed by all?
My lord.
Yes, my
All
lord.
the parties.
The terms of the learned counsels appearing for the party submitted that these terms of settlement are agreed upon by all the parties.
21 by 23.
Let preliminary decree be passed in terms of settlement which shall be part of the decree, which shall form part of the decree. Terms of settlement, full stop, full stop. GS 16 of 23 containing terms of settlement shall be part of the decree. Let the decree be drawn up. Other pending GS, pending applications are all pending applications are accordingly disposed of.
Grateful, my lord.
Grateful, my lord.
Item number 6.
Once the decree is passed, you all come together, mention it, then I will appoint, fix a date and appoint partition commissioner.
My lord. My lord.
আচ্ছা আরেকটা কথা লিখে দাও, department is directed to draw up the decree within the period of 15 days. Within 20th September.
Grateful.
Item number 6.
My lord, I am appearing for the plaintiff in this matter, my lord.
I am appearing for one of the defendants in this matter, your lordship.
Why it is fixed today?
My lord, this matter has come up at my instance, my lord. On the last occasion on 25th July 2023, your lordship was pleased to direct the substituted service in respect of some of the defendants who have refused, who could not be served properly with the writ of summons, my lord. Now, my lord, if your lordships take a look at the report of the registrar dated 9th March 2017.
এটা ঠিক once year হয়েছে তুমি জানাতে বললাম এটা কেন? শোনা কেন রেকর্ডিং করাতে গিয়ে নিয়ে গন্ডগোল না হয়ে যায় কিছু এটার জন্য
Application আছে মানে যেটা 23 তে ফাইল হয়েছে নেই না my lord, I hand up my copy, my lord. This is the report of the registrar wherein it is found that the defendant number 1I
This is your application for these GA are disposed of. All the GAs are disposed of.
disposed of, but this is the application wherein the report of the registrar is appearing, my lord. Well, the only point to indicate your lordship is that defendant number 1I.
Just a minute. So suit was to be heard ex parte against B, C, D, F, G, H, and J.
Yes, my lord. Now your lordship was pleased to direct that
I1I
for substituted service of summons. My lord, now 1I, as it appears from the status report, 1I has refused.
No, there was a report that it could not be served. Just a minute. So far as others are concerned, someone could not be served upon 2A, 2B, 2C.
Yes, my lord, 2A, 2C could not be served. We will publish the substituted service, my lord. Will cause substituted service. But the difficulty is that one I has refused to accept
What is
by
the report?
postal acknowledgement. My lord, will kindly find from the last column, my lord. That is through service through postal AD.
He was out of station.
My lord, thereafter,
One I was out of station.
thereafter, your lordship will find that he has refused to accept the writ of summons on 30th.
Where is the report?
Please, sir, please.
রিপোর্টটা আছে
ওটা নয়
ওই রিপোর্টটা এখানে নেই No, this report is not in the record. This report was not submitted. That's why confusion came up. Learned counsel for the
application
for plaintiff.
Plaintiff, my lord.
Plaintiff submits that defendant number 1I, defendant number 1I refused to receive the packet as appears from the service report of Deputy Sheriff of Calcutta dated 9/3/17. Full stop. However, the learned registrar administration, registrar original site, did not place that report on the last occasion. Let the report of the Deputy Sheriff dated 9/3/17 in this suit reports ঠিক আছে 9/3 along with other reports regarding along service reports be placed before this court on or before the returnable date so that necessary order regarding service of summon may be placed. Fixed.
Your lordship, before your lordship concludes the order, your lordship, I am representing 1C. On the last occasion, your lordship had, by the order of 25th July, your lordship had set ex parte against 1C. The lordship kindly does not do that, your lordship.
So far as report is concerned, report says you have refused. So you
Very
have
well,
to, once
but-
this order is passed, you have to, it is already passed.
Yes, your lordship.
So
But-
this will stand. You have to come with an application.
Very well, your lordship. And in fact, your lordship, I must point out, your lordship, on the last occasion, I had beseeched your lordships to kindly direct the registrar to kindly see whether any written statement was filed. And in fact, we have already found out that there is a written statement lying in the records on behalf of the original defendant number 1 already.
If the learned register shall also submit a report as to whether written statements are filed by any or all of the defendants.
আর application করতে
If you have a copy of written statement, produce it. I will send it for checking.
Your lordship, that we do not have. That we do not have. We have found out from the records only.
না আচ্ছা লাস্ট লাইনটা কেটে দিন লিখুন মিস্টার ঘোষ learned lawyer appearing for the defendant number.
Your lordship, I am not Mr. Ghosh, your lordship. Oh, for 1C, your lordship.
For 1C submitted that written statement on behalf of the defendant number 1C has already been filed. Although the suit is fixed for ex parte hearing against defendant number 1C.
Record করে নিচ্ছেন, জজ সাহেব।
Let a further report come from the learned registrar original site as to whether any written statement is filed on behalf of any of the parties, any of the defendants. না ওই জন্য ওনার সাবমিশনটা দিয়ে দিলাম। ডিফেন্ডেন্ট নাম্বার 1 এখানে 1 বলেছে 1 A B C তো এগুলো আছে। আরেকটা দাও দাও এইটা দাও। A further report is called for এইটা না ওইটা। In view of the fact that আরে এইমাত্র যেটা দিলে ডিফেন্ডেন্ট নাম্বার 1 এইটা না আরে রেজিস্টার অরিজিনাল সাইটে যে রিপোর্টটা এইমাত্র দিলে। হ্যাঁ কি বললাম? Is filed on behalf of any of the defendants. In this regard, therefore, in view of the fact that according to the report of the registrar original site dated 10th August 23, no written statement was filed by defendant number 1 without mentioning about defendant number 1B and others.
Your Lordship.
And in view of submission made by Mr. Dotto, that written statement has been filed by defendant number 1 say long ago. What is the next date?
Well, it was directed to appear on 23rd of August.
The suit will appear in the list on 8th September.
My lord, will kindly not keep it on 8th September, my lord. Any other date, my lord.
15th September.
My lord, obligement.
You're going somewhere.
For professional purpose, man.
Much obliged.
Where is Mr. Banerjee?
7 to 12.
7 to 12, my lord, may I indicate?
Applicant, my lord. My lord,
He-
the matter is
Well-
pending for maintainability of jurisdiction point. Similar matters are pending, which has been fixed on 8th of September by your lordship. My lord, kindly fix these matters also.
This is a matter relating to the.
Yes, I can remember.
Walkaway state principle.
Yes.
Yes, my lord. Mr. Banerjee appeared, came up with an application.
My
there-
basic point was that
My lord,
it has walk-off this court has jurisdiction
My
to
lord.
hear walk-off matters
Yes.
because in view of Pindari Faridi's judgment, some matters can be heard, some cannot be.
Yes, my lord.
Whether it falls on that.
My lord, your lordship, my lord, had directed, my lord, a day before yesterday, a batch of matters, as has been said by my learned friend
No,
before your
these
lordship. My
these
lord,
are
this,
different matters. Batch of matters maybe.
Hmm.
I like to fix
But-
it on some other day.
your lordship, my lord, any day after 8th, that matter is coming up on 8th, it may be fixed on any 9th, 10th or any,
That matter and these matter are different.
my lord.
My lord was referring to certain judgment of the Supreme
Yes.
Court.
Pindari Faridi, check it.
Pindari Faridi, yes. Pindari, yes, that was there, my lord. Thereafter, this 2022
down.
judgment, my lord, we
Write
had
it.
cited.
Come with all this judgment.
Yes, I have it, my lord. Every day your lordship fixes.
I am appearing on behalf of the Prince Ghulam Mohammad Waqaf Estate, my lord. In this matter, Mr. Ali is appeared on behalf of the Prince Ghulam Mohammad Estate, my lord. He is suffering from high.
All right, I'm not hearing any matter. I'm fixing a date.
Yes, your lord.
Only my lord, on the last of, may I just indicate, in this matter, my lord.
If slip-
Yes, sir. In this matter, my lord, on the last occasion, your lordship was pleased to give me a direction to file a supplementary affidavit in connection with IAGA number 38 of 2023. I have prepared it. I have circulated it to all the parties. My lord, item number 11, my lord, that's appearing. Let that be taken on.
Supplementary affidavit is filed in connection with.
No, I am speaking of item number 11.
Take a application.
You need a copy? You need a copy?
My lord, copies be circulated.
Yeah, we will circulate. Let them indicate who has not received the copy. We will circulate. Here is the copy.
My lord, I have not received, my lord. I appear, my lord, for one of the applicants,
How many
my lord, with great respect, my lord. I appear also for one of the applicants. My lord, my GA is not listed, my lord. My GA is my lord 959. That should be listed, my lord. Because for a comprehensive hearing, all the GAs in the suit, my lord, have to be heard. Since your lordship is hearing on maintainability, my lord, all the GAs have to be listed.
Supplementary affidavit is filed in connection with GA 38 of 23. Full stop. Let the same be kept in record and copies served. GA 9 of
959 of 2018, my lord. 959 of 2018 should be listed together, my lord.
new number.
No, my lord. New number, my lord. My advocate on record will give it, my lord. It's 959 of 2018. I'll give it, my lord. I'll see that it is given, my lord.
GA 11 of 2007.
Is 180.
15 of 2007. GA 20 of 2017. Sorry, 7. Yes. GA 20 of 2017. GA 21 of 2017. GA 38 of 2023. GA 39 of 2023 shall be taken up along with GA.
My lord, it is old GA is 959 2018.
959.
Greatly obliged. Yes.
959.
2018.
2018 shall be taken up together for hearing on maintainability issue.
My lord, may a copy of, my lord, GA 38 and 39 be served on my learned advocate?
Serve copies.
2014 SEC online.
Copies of the application which are still unserved may be served in the meantime. The matter will appear in the list on 15 September.
We will give them a copy. Mr. Ahmed is little bit worried whether I will give it. Oh, Mr. Hussain is worried that whether I will give a copy, I will give a copy. My advocate on record, well, it is there. He will give. He also. He.
No, good.
16. I will not come.
Could it be 19th, my lord? With great respect, could 19th, my lord?
19th.
All GAs to be listed. No, there are other GA also there, my lord. I believe Mr. Bakhtiar Shah has filed a GA.
Any other GA is there?
One GA is there.
There. Mr. Bakhtiar Ali Shah has filed. My lord.
The number.
GA number.
Mr. Bakhtiar Ali Shah has filed one, my lord, I believe. He has a.
Yes, Lordship, I am for
IAGA
Lordship.
IAGA number 29.
Other GAs are pending.
IAGA number 29 of 21. That's a application filed by the KMC.
IAGA number
29 of 2021.
2021. 5 September 5th. IAGA number 29 of 21.
My lord, I will just indicate one thing. That GA is due to appear on the 5th of September.
No, that will I will adjourn it since these are all 15.
It was my duty to indicate.
Any other matter? Any other GAs?
No, that's all.
All right.
Greatly obliged, my lord. Affidavits in the meantime, my lord. If anybody wants to file affidavits in the meanwhile.
Parties are at liberty to file affidavit in the meantime.
Greatly obliged. Much obliged.
Item 13 and 14. Kantimay Kundu Chaudhary.
On behalf of
Joint receiver. My lord, this is an actual cost item. Can I file this? This is
My lord.
actual cost item.
My lord, for item number 13 and 14, I am the applicant, my lord. And in this, both the petition.
File this.
Okay, my lord.
Give it.
Now just showing this. This is the actual cost item.
My lord, there is a defect in cost title, my lord. My prayer is to carry out the amendment of the cost title. After filing these two applications, 3 defendants were added in the original cost title.
That cost title is to be changed.
Yes, my lord. That is she is showing.
Cost title is to be changed then.
No. This, from earlier, there only 35 parties.
Then amateur 35. Well, they prayed, placed before the honorable court on earlier occasion that there are 38 defendants, my lord.
38 defendants are there. Have you mentioned all their names?
My lord, in my application, I mentioned 35 defendants, my lord. I need to carry out the
Then your application should be changed.
Yes, my lord.
You withdraw it and file afresh.
File fresh.
Yes.
Yes, my lord.
Which one?
244 and 245. Item 13 and 14. It is one is restoration application and one is condonation of delay.
The learned counsel for the plaintiff.
Applicant in 223, my lord. GA 223 of
You are plaintiff or defendant?
I'm defendant. I'm an applicant, my lord, not a defendant also.
Of GA number 244 of 23 and GA number 245, both
Yes, my lord.
of 23, craves leave to withdraw the application for some technical faults and to file it afresh. Leave is granted. Let GA 244 of 2023 and GA 245 of 2023 be disposed of as withdrawn. The matter will appear in the list on 20th September.
My lord, kindly direction to carry out the changes in terms of
You are
original
withdrawing.
claim.
You are withdrawing. So
Yes, my
you
lord.
will file a fresh application.
I have to see the name of defendants from the original plaint, my lord.
So you have to inspect the record.
Yes, my lord. I pray for a direction for that, my lord.
Leave is granted to the learned counsel for
Inspection of the original plaint, my lord.
for which party?
For applicant in 223 of
Which
22.
applicant? This is no longer existing.
My lord, it is an applicant in GA
Are
223
you a
of 2.
party or not?
No, my lord. I'm an intervening applicant.
Say that you are intervener.
Yes, my lord.
Have you filed wakalatnama?
Yes, my lord.
Inspect the learned counsel for the intervener craves leave to inspect the record. He is at liberty to inspect the record and department shall permit so in accordance with the rules of the original site.
My lord.
Matter will appear in the list on কবে বললাম? 20. Suit. What is the stage of the suit? Suit.
It's pending, my lord.
Item 15. Onusam Bagdi.
My lord, this is my application.
You are for plaintiff.
Lordship, I appear for defendant number 1D by 1, your lordship.
Well, I will.
Where is the link? Link open.
Lordship, there's some technical problem, which is why my video is not switching on, your lordship. I apologize for the same.
Come before the court.
Item 16.
For the defendant.
My lord, my application, my lord, this application is for appointment of commissioner. The suit is of 2001, my lord. Thereafter, a decree was drawn in 2014. Thereafter, my lord, it was set aside by an order, my lord. Kindly come to page 21 directly, my lord.
This is an application for appointing a commissioner for reducing evidence, my lord. My evidence is all along finished, my lord. Only 1 day is required, my lord. At this stage, my lord, if it is rather further delay the matter, my lord.
My lord, they will bring
it is fixed on 14th, my lord. It is fixed on 14th September. And I will not take any further adjournment on that day, my lord. On 15th,
My lord, thereafter, they'll bring one more witness. You move. My lord, they have one more witness, my lord. Already, my lord, kindly come to page 21 once, my lord. Let me. This is the order where the decree was set aside by the division bench, my lord. Second paragraph. On such consideration, we set aside the impugned judgment. We request the learned single judge to proceed the hearing of the suit from the stage of giving an opportunity to the defendant to cross-examine plaintiff's witness and to lead any evidence in support of defendant's case if they so desire. In view of the fact that the suit is pending for long, we request the single judge to pass preliminary direction with regard
whom you want to examine.
My lord, their chief is going on, my lord. But it's sometimes their witness doesn't come. So if a commissioner is appointed, my lord, it can be done on day-to-day basis, and the suit can be disposed. My lord, it's a truth.
Who will be examined?
Their witness, defendants, TW1, my lord. Plaintiff's witness has been examined, my lord. Cross chief completed.
Plaintiff's
Witness has been examined. Cross chief has been concluded. DW1 and they might bring one more
what
witness.
have you, where have you mentioned it will be DW1? Where
My
have
lord,
you
I've-
mentioned for examination of DW1?
My lord, I'm not, their chief is going on. I've prayed for
What application is this?
my application, my lord.
Why you have made this application?
For appointment of an commissioner, my lord, so that the matter can be expedite, my lord.
What commissioner will do?
To record the evidence, my lord.
Whose evidence?
DW1's, my lord.
Have you mentioned this? Where have you mentioned? Show me. Show me.
My lord.
Evidence of witness. Which witness? Where have you mentioned? It will be DW1.
My lord, DW1 and DW2, they might bring one more witness, my lord. Both.
Where have you mentioned that it will be examination of defendant's witness? Maybe DW1, 2 to 10. Where have you mentioned this? You're absolutely silent on this. Your pleading is not clear. Would you examine DW1?
My lord, I am examining DW1 chief, my lord, and it's almost complete. My lord. More than 800 questions have been set, my lord. Last few questions are left.
GA number 11 of 23 is filed with a prayer to appoint advocate commissioner for conducting deposition part and recording the evidence of the witness brought in by the party. Full stop. The learned counsel for the defendant submitted that witnesses on behalf of the plaintiff has already been examined, cross-examined and discharged. Full stop. Different DW examination of DW1,
my lord,
examination in chief of DW1.
My lord, this is my submission, not this is the plaintiff's submission. That
it is not his submission. You have contradicted the DW1. Then first thing you are silent about who is to be examined. Then you are come here to rectify me.
I'm just.
You will them?
Chief of DW1.
It's going on. Full stop. In view of order passed by the Honorable Division Bench, let an advocate commissioner be appointed for examination of defendant's witnesses on defendant's witnesses. Examination witness shall be complete within a period of 1 month. Cost of advocate commissioner shall be borne by
the plaintiff.
My lord,
will pay my
the plaintiff as stated in prayer C.
My lord.
Who will be there?
My lord, any junior member, your lordship.
To name it.
Arif Ali. Arif Ali.
Arif Ali, what is the address? Bar Association number?
Bar Association. My lord, I'll give it.
Give this. The advocate so-and-so shall be appointed as an advocate commissioner, mobile with mobile number. Remuneration?
Whatever your lordship thinks.
One-time remuneration of the learned advocate commissioner shall be 50,000.
My lord.
This apart, traveling expenses shall also be borne by the plaintiff, or arrangement shall be made for traveling, for to and fro journey. Let the matter appear in the list on 5th October for report of the advocate commissioner.
Lord, there is one more date fixed for on 14th September. Let that may be cancelled. It is fixed for your lordship for witness.
What you come on that date?
On
I will change it. You come on that date.
And my lord, my affidavits have not been filed, my lord, so the contentions are not.
GA 11 of 23 stands disposed of. I have noted your submission.
Grateful.
My lord, certain allegations were made, so I have not filed my affidavit, so it should not be taken.
All right.
Lordship records, my lord.
This application is allowed adjudicating on the respective the allegations made by the plaintiff against the defendant. Oh, ওইটা দিয়ে দাও, একটা স্ট্যান্ডার্ড লাইন দিয়ে দাও। The learned registrar original site shall depute one responsible officer for carrying the record along with the learned advocate commissioner. Either full stop, either arrangement of traveling shall be made of such officer by the plaintiff or the plaintiff, no, alternative, no. Plaintiff shall make arrangement of traveling of the officer so appointed from the High Court to the place of commission and back.
My lordship is deciding the venue or it is left open, my lord?
No, it's left open. You give the slip, name, mobile number, and bar association or bar library club, whatever that might be.
Item 17.
My lord, 17 and 18 is that Hatras matter. My lord came today, day before yesterday. My lord directed the other side to they sought a leave to file their notes of argument and serve the prior property.
That is not done.
Not done yet, and in fact, my
Mr. Gupta has not prepared that.
I had prepared that. I have
Not
a leader.
complete.
I have a leader now, my lord.
My lord, may that be
Is that an explanation for,
Because you are a scapegoat.
is that an explanation for not preparing a note? I have a leader. My lord,
let that be completed so that we can finally conclude our argument on the next day.
When will you come? 7 days?
not comment. Yeah, whenever your lordship business, my lord, except for 8th.
No, how many days will you take for preparing this?
My note is ready, my lord. I wanted my learned senior to have a look into it.
My lord, any day next week, my lord.
Except 8th.
On prayer of the learned counsel, you are for?
We are for the defendant number 1.
Defendant number 1. The matter is adjourned to দেখো তো একটা ডেট কবে আছে 13 September.
My lord,
Filing notes of argument.
My lord, let that be a peremptory direction, my lord, because we
I will
can
not allow
conclude
them.
and let them serve a copy at least 2
Yes,
days prior.
serve copy.
Are you filing a note?
My lord, if
No, there is no notes can't be exchanged because
my lord,
are you filing a note? Yes or no?
we do not
Then tell
require-
them.
You have to file a note.
My lord, at least let them serve at least 7 days prior them so that we can file it within that our final.
I am fixing it on 13. They will have to file it. Why 7 days time?
My lord, let them serve a copy.
Let
prior to
that be filed. On 13 I will pass it.
Okay.
This,
Thank you,
my lord, I'll tell your lordship one thing, though, my lord, your lordship. My lord, what happens is this, my lord, I have found, my lord, that after pleadings are complete, pleadings are supposed to be, my lord, the basis of it. Now, my lord, notes are there only for the purpose of assisting the court as to what
Absolutely.
points have been
Nothing
argued.
more. Because
Now,
so
what
many
happens
documents
is, what
must be
happens
consulted.
is, now, once I give him a note, then he gives a counter note dealing with my points. So better is we file our notes to court. We don't exchange any notes.
All right, do that.
For framing of issues.
Basically, number of documents are there.
No, that
We
we
have to
indicate
consult.
in the note. But we'll file it in court, we'll not serve. And my learned friend will file his note, we don't want a copy of
18
it.
also.
18 my lord is a
18 GA number, 18 GA is our application, my lord, under 2A, my lord, and 17 is appearing at their instance only. The
What is suit?
It has no relevance with our application.
So
that
both
my lord
will
said.
be heard together.
No, we were actually trying to say that let the partition suit, which is pending for the last 33 years.
Let that be
And no-
expedited.
Yes.
My lord,
All right, you come it unless these are disposed of, this cannot be made.
No, this GA has been made in 2023. The suit is of 87. No steps have been taken.
Come with the notes of argument, I will pass necessary order.
Yes.
my lord, they are the defendant. There was direction upon the registrar to file a report whether they have filed a written statement in the plaintiff or not.
Yes,
My-
that was the point. Last date
I
I
don't know
raised.
whether the report has been filed.
দেখুন তো written statement আছে কি
No, the report
সব
register
কটা
will,
ফাইল করে
register will submit.
Let that be there, my lord. We can.
Date bolam to. The learned registrar original site shall submit a report as to date of service of summons on the defendant, comma, date of appearance, and date of filing written statement. Oh, আচ্ছা, লাইনটা কেটে দিন।
কি বলছে হয়েছে না হয়নি? হয়ে গেছে?
Two written statements have been found to be filed. One filed by 2 and 5, other by 1.
That's my client. I have filed my district.
Yes, number. How many defendants are there?
Well, there are at least, I found in G in C 18. 6.
আচ্ছা, ওইটা থাক।
6. 2 to 5 and 1 mean all day.
হ্যাঁ, থাকবে, থাকবে।
So all 2 to 5. There are 6, 2 to 5 and 1.
No, 2 and 5.
Oh, 2 and 5. There are 6.
1, 2 and 5.
এটা তাহলে অন্য সুটে আছে।
Another suit.
That is in CS 118.
118. We are in.
No, this is 1166. Well, 180 is connected with this in the sense, Millard, that in the party.
In ওইটাতে লিখে দিন, যেটা ডিরেকশন দেন না, in CS 1166 of 1987. Ledger is badly torn. Could not comprehend as to whether written statement has been filed.
Then we will have to assist the to find out whether written statement
And to suggest whether any reconstruction of record is needed if written statements are not available.
Item 19. Framing of issues.
And I have, my issues are ready, my lord. My appeal for the plaintiff.
Who is for defendant?
My lord, I have instruction to appear on behalf of defendant number 1 and 2.
Are you filing any suggested issues today?
No, my lord. The difficulty is not. I'm the current conducting advocate, my lord, but I have not been able to obtain no objection from the erstwhile advocate since he is not traceable. For which, my lord, I have not been able to inspect the records of the court as well, my lord. Without filing vocal now, it's not permissible.
I'm giving you 1 day accommodation. Inspect, do settle your.
This is going on for some time. My lord, orders will be evident from this, my lord.
Not this week.
My lord, with your lordship's leave, my lord, with my seniors leave.
Well, not this.
Not this week.
Should be the last, the third occasion, I believe.
Only not this week. Remind me on that next date.
I am not uttering a single movement. Obliging.
Item 20.
My lord, I am appearing for the defendant number 1A. My lord, today, my lord, the matter is fixed for, my lord, framing of issues, my lord. My lord, my suggested issues are ready.
For the defendant.
My lord, I am for defendant number 1A.
Who is for the plaintiff?
I am for the plaintiff, lordship. Yes, lordship. My suggested.
Give it. Both of you give it.
My lord.
I will frame the issues. এটা পাঠিয়ে দেবে রেকর্ডটা।
My lord, is it my lord's pleasure to, my lord, fix a date, my lord, for my lord?
Check the order. I will mention there.
Very well. Grateful, my lord.
For hearing. Item number 21.
Lord, I appear for the petition. Your lordship already heard this matter on many occasions. This is with regard to a trust property, 2 trust properties. But I shall place my case, my lord, one after another.
For Administrator General, you are for.
Yes, ma'am. I am led by Mr. Indranil Nandi. He is in code number 41, ma'am.
Let him submit.
May I start?
This is J number 1.
Yes.
Where is the record?
J number 3, sir. Achha.
Finalize the accounts.
Yes, our prayer is, my lord, that finalization of the accounts, official
Order sheets.
trustee directed to finalize the
Order
account.
sheets. Order sheets.
That is prayer A of the petition.
Report has been filed by the official trustee.
Yes, yes, my lord.
Petitioner is to file affidavit in reply against the report.
Original, my lord, we have already filed, that is fine, on record. Huh? Original, we are just handing up, my lord. Original,
What you have to say on this report?
my lord, I shall
Because
place,
you prayed for finalized account that is submitted.
there are serious anomalies, I shall show to your lordship. How the accounts have been prepared, one,
This is your application, but what is your,
my lord, what are the grounds in my application? Lordship, kindly have to see first. But I am just placing I'm arguing my case, then I shall place the documents.
no, it's not a question of document. As per your prayer, receiver was directed to file final accounts.
Yes,
That report is placed.
yes,
You file exception against that.
yes.
Now, what are your objections? Give me points. What are your objections?
My lord, not only one objection, my lord. Lordship, can you see my reply?
Yes, that's why I want
Reply to
to.
the-
What grounds have you taken?
My lord, lordship, kindly come to page 3 of my reply, paragraph 4.
Where is the reply?
Lord, reply টা যেটা আজকে ফাইল হলো এখন ছোট্ট yes yes এই ওইটা আজকে
This is application under
না না না
29 Act.
এখন আমরা 18th আগস্ট 2023 ছোট্ট এইরকম সাইজ ওটা দিলেন তো কোথায় গেল জাস্ট নাও উই হ্যাভ হ্যান্ডেড আপ হ্যাঁ এখনই এটা দিয়েছি
আরে এইটা নাও না তাহলে
18th affirmed on 18th of August 2013.
Affidavit of reply. Yes, it is with me.
Yes.
রিপোর্টটা কোথায়? রিপোর্টটা একটু দাও।
আরে সে কোথায় দেখো না ওকে কাগজ দেবে ভালো এই কাগজটা দিতে হবে ওদের এটা বার করে দিন ওরা যেটা লাস্ট ফাইল করেছে ওটা কোথায় ওদের অ্যাকাউন্টসটা দেখতে ওদের রিপোর্টটা ফাইল করতে লাস্ট এটা কোর্টে অর্ডার প্যারাগ্রাফ 4টা করুন ওদের অ্যানেক্সার আছে
কোনটা দেখাচ্ছেন লাস্টের যে
লাস্টে
আপনারা যেটা ফাইল করলেন
হ্যাঁ ওদেরটা কই এটা লাস্ট দিয়েছে এটা না লাস্ট যেটা দিয়েছে আরে এই এফিডেভিটটা সাপ্লিমেন্টারি এফিডেভিট হ্যাঁ
সাপ্লিমেন্টারি এফিডেভিট এটা এফিডেভিট ইন রিপ্লাই তো
ওটা তো এফিডেভিট কি ওরা দেখ হ্যাঁ এটা আমাদের রিপ্লাই হ্যাঁ
তাই তো এটাই দেখেন
না আপনাদেরটা চাইছি আপনাদেরটা কোথায় ওদেরটা আরে সাপ্লিমেন্টারি এটা লাস্টের দিকে হবে 8 দেখুন 8 এটা সাপ্লিমেন্টারি ব্যাকটা দেখুন না এতে কোনো এগিয়েছে অ্যাকাউন্ট থেকে দিয়েছে হ্যাঁ
আচ্ছা এইটাতে একটা অর্ডার হয়েছিল না সেই কর্পোরেশনের চিফ ইঞ্জিনিয়ারকে ওটা গেছিল
কিচ্ছু
যায়নি কর্পোরেশন
ওসব ব্যাপারে
না এটা বলতে হবে বলতে হবে
Let me go through the papers first.
Yes, but there are huge papers.
Well, one humble submission. Another, I thought I mentioned. Well, there was an earlier order of your lordships in this matter, directing the chief engineer of the Kolkata Municipal Corporation, well, to inspect the building, well, to determine and the condition of the building and the repair which is required. Well, I understand that order till today has not been carried out by the Kolkata Municipal
That
Corporation.
will take care of later.
But now we are at the final hearing
Please
stage.
go through your account.
Lordship.
We'll come back with these accounts itself.
Lordship.
May just place our reply to these accounts.
Let me go through it. How can I
Yes,
understand
yes,
submission of that?
Lordship.
GA1, hearing of GA1 of 21 is adjourned to 18th September.
Or 18th.
18th. এটা রেকর্ড দিয়ে দেবে আমাকে।
আলাদা রাখবে।
Lord, I am ready to argue the detail on the
Let
next
me
step.
go through it.
Yes, yes,
How can I
obviously,
appreciate your
obviously.
argument?
This is a matter of accounts, yes. But if necessary, we shall file a detailed notes on argument after the
Let me
hearing.
first go through
After
it.
the
If
after the
necessary,
hearing
we'll
is
do that.
after
If
the
you want
after
to
the
do that,
hearing
you
is
come
over.
with a note.
Yes, Lordship.
Item 22.
Milord, this is an application under Order 7, Rule 11.
The Chaudhary's argument was finished.
Finished, Milord. I have to, Milord. I am very sorry, Milord. Yesterday I couldn't be there. Well, I was in 23, but I apologize. Milord, suit, Milord, challenges, Milord, to orders, Milord, passed by this court, Milord. And, Milord, the orders were subsequent, Milord, to the filing of the suit, Milord, were confirmed by a subsequent order. So, Milord, the issues were decided there. Subsequent to the filing of the suit. Now, Milord, it is well known, one of the ground, Milord, is taken in the suit, Milord, in the application, Milord, is, Milord, the suit is, Milord, barred by law. That is the principles of res judicata. Now, Milord, it has been held by the catena of judgments, Milord, or by the apex court, Milord. Res judicata is a point, Milord, which cannot be thrashed out in the Order 7, Rule 11 stage. Milord, Mr. Dasgupta is appearing with me in the matter. Lordship's query was, Milord, look, in the Milord plaint, you have asked for declaration that the orders passed by the division bench, Milord, is a nullity or, Milord, void. Can I, sitting here, do it? That was the query of your Lordship, Milord. Now, I have checked up the law, Milord. The point of invalidity or a nullity, Milord, can be set up at any stage, even at the execution or in collateral proceedings.
Doesn't mean a single bench will set aside the order of a division.
That can, Milord. Even, Milord, I have, Milord. It's a question, Milord. Milord, there are other prayers also. That's a second argument.
Look, Mr. Chaudhary's argument is that suit is barred by res judicata.
Yes.
It is well settled. Res judicata is a mixed question of law and fact.
And, Milord, cannot
First
be
thing.
decided.
Second, which cannot be decided, that can be decided definitely, but not in hearing.
Not in Order 7, Rule 11 stage.
Second thing is that Mr. Chaudhary referred to a judgment which is passed subsequently, which is extraneous to the plaint.
Yes, absolutely.
But
correct.
We are concerned with the plaint itself.
Yes.
Prima facie reading of the plaint.
Yes.
You clarify one or two points. First thing, what I asked last day.
I'm carrying judgments to that effect.
First thing. Second thing, it's not a fact that you are not aware of the thing. It is in your plaint.
In my plaint. It's my plaint, Milord. I have, Milord, challenged a decree or an order, Milord, passed by the division bench. I have done so.
In a single bench.
Before naturally, Milord, I cannot, Milord, file a, Milord, application in a disposed of matter.
That is one thing. Yes. But question is,
so whether the suit will lie, Milord. This type of suit will lie or not lie. I'm giving. Now, Milord, kindly, Milord, I'll answer all the questions, Milord. Because, Milord, it's not today, Milord. It has been held, Milord, right, Milord, from, Milord, 55 Supreme Court, Milord, that invalidity, if someone raise, Milord, he can, Milord, set it up, Milord, by in a collateral proceedings. If Lordship, Milord, takes the plaint once, Milord, my application, the plaint once. We discuss.
Come to the plaint.
Yes, I'm coming to the plaint. Milord, kindly gives me. Milord, the plaint in my lords, in the application which has been filed, Milord. So it's a very yes. I mean, it's, Milord, page 39, Milord, of the application. If your Lordship, Milord, is kind enough.
Application or plaint?
Milord, page 39. Lordship will take the plaint, Milord, of the application. Page 39, 3939.
Plaint is with me. Are you referring to the plaint?
Yes, I will do it separately, Milord, if the plaint is separately. Yes. Ote plaint ache, plaint alada judge saheb bolchen ache.
Plaint ache.
Plaint alada ache. So, Milord, I show, Milord, separately, Milord. Kindly, Milord, Have a look, my lord, who are the parties to the plaint. Sarda Devi Chaudhary, Shushil Chaudhary, Sanjay Chaudhary, Dedraj Chaudhary, Triveni Chaudhary, Vinod Kumar Agarwal, Srimati Manju Agarwal, Rajiv Agarwal, then my lord, other my lord, the family companies or the partnership firm. Now, my lord, first of all, now lordship straight away comes to the prayers, which is at page 33 of the plaint. Kindly have a look at the prayer. The first prayer is, my lord, declaration of a memorandum understanding, which is annexure E, is illegal, null and void, and not binding on the plaintiff. That lordship will find annexure E to the plaint, which refers, my lord, to, my lord, a memorandum wherein, my lord, it is sought to be held not binding on the plaintiff. Now, my lord, prayer B. Kindly now take prayer B.
Just a minute.
Annexure E. Annexure E. My lord, annexure D is the order.
Yes, then annexure.
Annexure E. That is
Yes,
page,
I found out E.
yes, page 91.
Page 91.
Very,
Then
my lord. So, my lord, this is what I have asked for, my lord. Declaration.
cancellation.
Cancellation, my lord.
Then
now, my lord, I can maintain a suit for cancellation of this particular agreement.
cancellation of instrument according to you.
According to me, my lord. The grounds for cancellation would be, my lord, that, my lord, this is a family settlement, my lord. Deals, my lord, with immovable property, the value of which, my lord, is rupees 500 and upwards, my lord, should be stamped and registered. The stamping and registration will be an issue here, because immovable property are dealt with in this by way of the memorandum, my lord, by way of the memorandum. This is point number 1. Point number 2, my lord, it's part of the plaint. The order, my lord, which, my lord, I'll answer. Order, my lord, the appeal number such and such, including annexure E, are not binding on the plaintiff.
E is not the annexure. E is only
Memorandum. Memorandum, my lord, that's E, my lord. Lordship
the
will
order
take,
you are
my lord.
referring to.
Declaration. My lord, kindly take declaration that the memorandum of understanding being annexure
Right, but
E.
which order you are referring to?
Now, my lord, kindly take prayer B, which Mr. Chaudhary harped upon. Declaration that the order passed in appeal number.
That order.
My lord, I'm showing, my lord. That's, my lord, annexure D. That's annexure D. That's page 85. Or, my lord, lordship starts from page 84. That is, my lord, part of the plaint, I believe. Has lordship found out? All the interested parties in the present in the court today, they have agreed that the property should be divided equally among the 3 parties. Further, his 2 sons will accept the terms as may be suggested by the court regarding the allocation of the properties, lest the matter appear on the list on such and such for orders. Now, kindly now take, my lord, page 85.
Which order you are seeking to set aside?
Page 85. The annexure D, my lord, this is the reference to the plaint. I am going by the plaint, my lord. I have to survive or fall by the plaint itself and nothing but the plaint.
You have made one mistake here. Annexure E, it should be annexure D.
My lord, annexure, my lord,
It
what?
should be D.
Annexure D is the orders.
That should be D. Declaration that order passed in appeal number 504 of 1992.
Yes, yes. That should be, my lord, that should be, my lord, D, not E.
E.
Correct, my lord. Lordship is absolutely correct. So, my lord, I take, my lord, the bunch of orders, which is, my lord, annexure D to the plaint. We take a holistic, my lord, representation of the plaint or what has been challenged in the suit. So, my lord, this is what we challenge by way of a filing of the suit. Now, kindly takes the third prayer. Perpetual injunction be issued restricting the defendants and each of them and as servants, agents, assigns from giving effect to the memorandum of understanding being annexed
So
E in
basically
any manner.
this springs from A.
Springs from A. Lordship is absolutely put the phrase, my lord, in the right manner, my lord.
B,
Then, my lord,
E also.
yes. So, my lord, what is the first prayer? If your lordship, my lord, forgets for the time being, my lord, everything, my lord, is flowing from prayer A. There is no dispute, my lord. A memorandum of understanding can be challenged.
So your basic prayers are A and B.
A and B.
And these
So,
are
my lord,
delivery prayers.
these are, my lord, ancillary prayers.
Yes.
These are ancillary prayers. So, my lord, lordship will take a situation. If a part, I am saying, my lord, this can be granted as an alternative argument because I have authorities to cite, my lord. That, my lord, if my lord, lordship holds, my lord, finally, not in an order 7 rule, because there cannot be a partial rejection of the plaint. If lordship, my lord, there are prayers, my lord, A, C, and my lord, E to, my lord, E to H are the prayers which are flowing from A or are independent of A. So, my lord, this, my lord, if my lord D cannot be granted to me, ultimately, if my lord courts are hesitant, my lord, to say why should I touch an order of an appellate court? That I put it in this way, my lord. No point, my lord, giving a my lord problem. It's a solution. My lord, then even my lord, the plaint can't go because there are other prayers also. Only because one of the prayer, if at all, cannot be granted. I'll show the judgment, it can be granted. Because, my lord, supposedly, my lord, I give a situation in this way.
One thing is clear, plaint cannot be rejected on the ground of res judicata, but because two issues are there. First,
Yes.
res judicata is a mixed question of law and fact.
Correct.
Second thing, here in this case, the issue of res judicata is extraneous to the plaint.
Extraneous to the plaint.
That cannot be considered.
What is troubling your lordship, my lord, is prayer B.
Yes.
So, my lord, prayer B, my lord, itself, ipso facto, cannot be a ground for rejection of the plaint. Because there are other players also.
You show the authorities because I have to study those things.
Yes. My lord, may I, my lord, just, my lord, indicate I am carrying, my lord, I hand up, my lord, the notes to your lord, my judgments to your lordship. Now, my lord, have a look at. So, my lord, this is all. Now, my lord, come, let us now restrict ourselves to prayer B. Let us, my lord, take, my lord, the bull by the horns. My lord, A and B are documents, my lord, in relation to an immovable property. The value of which, my lord, are, my lord, over rupees 500. If an order, my lord, deals with an immovable property, my lord, it has to be stamped, registered. If a decree, my lord, deals with, my lord, lordship notes, stamped, registered. Now, the memorandum of understanding, my lord, has to be stamped and registered. At least stamping should have been there, my lord. So, my lord, these are, my lord, insufficiently stamped documents. Can't, my lord, can a defendant or a plaintiff, can a party, my lord, rather I put it in this way, raise the point of unenforceability or invalidity of the document on the ground of stamping and registration in the execution proceedings. This point was not taken, my lord. It went up, my lord, a decree is confirmed right up to the Supreme Court. When the execution, my lord, is before the single judge or the munsif, I put it the munsif or the, my lord, sub-judge, my lord, in the lower judiciary. Can that point not be taken in execution? That's the reason, my lord, the Supreme Court says, my lord, a point of invalidity can be always taken in collateral execution as well as in collateral proceedings, my lord. My lord, this is, my lord, well settled. This is, my lord, 1993, 1996 3 SCC, page 301. দেখছি রে। Kindly, my lord, now takes, my lord.
Para 6.
Yes, para 6. My lord, last portion. Once a decree is held to be a nullity, the principles of res judicata will have no application and its invalidity can be set up wherever it is sought to be enforced.
Obviously, because once a decree is nullity,
yes,
there is no question of finally adjudicating a claim.
Absolutely. Now, my lord, lordship has to be hear me why the decree is a nullity. Then, my lord, I have the chance because I am on a better footing. I am defending my plaint. the defendant is on a Millard on a sticky wicket or a weaker footing because he has to proceed on the basis of my plaint. Now, if I prima facie show from my documents that the memorandum is dealing with Millard immovable property, the value of which is rupees 500 and above. The order deals with immovable property, the value of rupees 500 and above. Even it is acted upon by some of the parties or advantage is taken. Millard, that is Millard the invalidity which I sought to be raised here. Lordship sees it, whether it can be enforced, legally enforced. So, Millard, this is the judgment on the point. If your Lordship permits, may I, Millard, read paragraph 5.
One thing is that a document, your prayer is not tenable. That is one thing.
Yes.
And another thing is the document you are seeking for or relief in respect of the document, that is not valid.
Yes,
that cannot be taken at this stage.
Yes.
Issue is whether your prayer is tenable.
Yes. Millard, kindly now takes the prayer. Millard, declaration of a memorandum of understanding being annexed is illegal, null and void, not binding on the plaintiff. Section 34 of the Specific Relief Act straight away. Millard, any injunction in aid of that prayer under Section 38 of the Specific Relief Act straight away. So, Millard, where is the problem, Millard? In law. And so far as declaration prayer is concerned.
But you understand your point is that first, these issues can be taken up in collateral proceeding.
Absolutely.
As you referred.
There is a
Second point
5-bench Millard Supreme Court on this
Second
issue.
point is that even if there may be some reservation regarding prayer B,
yes,
prayer E stands all right.
Yes.
Plaint cannot be partially rejected.
Cannot be partially rejected. You have to go or leave.
At best, I can ignore that prayer.
Can ignore that prayer. In the final relief, not today.
Ignoring a prayer is not rejection of a prayer.
Absolutely. Not today. It has to be, whatever has to be done fine. Kindly take a note of it. Millard, why and how? Why this application, Millard, crops up, Millard, in Millard, today, Millard, for pressing it, Millard. Today, Millard, there is no written statement on board. Kindly appreciate. This is also one of the factors. Though it's a normal suit, not a commercial suit, the regards of 15 or Section 16 of the Commercial Codes Act 2015 doesn't apply. But, Millard, this is a suit of 1997. Millard, so Millard, at least Millard, 26 years have gone by. The defendant did not.
That point will be taken care of later. But
Yes.
first thing is whether suit can be rejected at this
Yes,
stage.
Millard, someone who has not filed a written statement for, I am also arguing it, Millard. Someone, Millard, who has not filed a written statement for 26 years. Millard, now Millard, he knows, Millard, that there is a difficulty in taking the written statement on board, Millard. Presses an application which is pending, Millard, since 1997, Millard. And Millard wants to succeed, Millard, an extraneous consideration. A condition which is alien to Millard, the plaintiff. Because, Millard, Justice Rumapal's decree, Millard, is, Millard, subsequent to the plaintiff. My learned friend's argument, so far I could understand, Millard, this particular order at prayer B has merged with the final decree of Justice Pal. Millard, Justice Pal's decree, Millard, I just put it, Millard, Justice Pal's decree, Millard, was challenged, Millard, by, Millard, all the parties. Why it was challenged, Millard? Kindly have a look at it. Why I say it's unenforceable. I proceed, Millard. You look at the decree. Why, Millard? Because A, there was no schedule to the properties. Now, Millard, in respect of, Millard, decree of immovable property, Millard, it has to be passed as per the appendix, Millard, of the Code of Civil Procedure, Millard. There should be a schedule. Unless there is a schedule, it cannot be, Millard, sought to be executed or enforceable, Millard. Kindly have a look at it. Now, Millard, this point of enforceability, Millard, the person who is the applicant today, Millard, takes a point, Millard, in this special leave petition. The special leave petition gets dismissed. So, Millard, the point of according to this particular, Millard, the applicant who is moving the application today, the decree of of the division bench, Millard, presided by Honorable Justice Rumapal, Millard, is not enforceable because it lacks a schedule of properties. He today comes forward. This is very important. I am on conduct. He today comes forward and says, Millard, that, Millard, because of this decree subsequently, this suit is hit by res judicata. Please dismiss it as a demander. Is it permissible in law? I am going, Millard, whole hog. Firstly, Millard, that decree, Millard, today has not been put into execution. Kindly, Millard. Division bench, Millard, subsequently deals with the decree. There is a subsequent division bench. Millard, a decree is enforceable for 12 years from date of pronouncement, from not the date from, Millard, when, Millard, the defendant or the, Millard, person who has got the decree, Millard, has Miller woke up and has filed an application for drawing up and completion of the decree. That's not the law. You may do it, but that's not the law. It's Miller 12 years from date of Miller when the judgment is pronounced in court. So that's Miller. So 1997, 12 years takes us to 2009. Today we are Miller in 2023. The decree on the face of it is, if at all it is held to be Miller enforceable legally, Miller can't be executed. Where is the question of res judicata? It's not a declaratory decree, Lordship. The decree, Lord, divides the rights, title, interest of the parties in respect of a immovable property.
Next judgment.
Now, Lord, the next judgment on the point.
I'm returning it to you. Come with compilation.
Very well, Millard. Now, Millard, kindly, Millard, takes Millard the judgments, Millard, which I have prepared, Millard. Kindly let us go one by one. So, very Millard, আমি একটা কম্পাইলেশন করে না জজ সাহেবকে দিয়ে দেবো একটা একটা করে।
এগুলো আমি জাস্ট দেখছি এখন, আমাকে দাও, আমি
আপনার কাছে রাখুন, আমি একবারে নিয়ে একবারে কম্পাইলেশন। এটা দাও 2012 SCC। Yes. 2012, 2020, volume 12 HCC 809. Lordship will kindly now take, I'll be very short, Millard. I have marked the paragraphs. I'll not read the entirety. I'll read the not.
Res judicata cannot be considered.
Yes. Kindly, Millard, have a look at para 13 for my satisfaction. Only this I'll place in detail. Rest, Millard, I'll indicate the page number. I do not want Millard to waste Lordship times. In this regard, pronounces in Kamla versus such and such, we would simply, in a case dealing with the principles engrafted in Order 7, Rule 11D, the court held thus. Order 7, Rule 11D of the court has limited application. It must be shown that the suit is barred under law. Such conclusion must be drawn from the averments made in the plaint. Different clauses in Order 7, Rule 11, in your opinion, should not be mixed up. Whereas in a given case, an application or rejection of plaint may be filed for one or more grounds specified in the clauses thereof. Clear finding.
You will get in the next page.
Yes. Kindly, Millard, takes the next. Yes, absolutely.
23.
Yes, 23. The principles of res judicata, when attracted, would bar another suit in view of Section 12 of CPC. The question involving mixed question of law and fact, which may require not only examination of the plaint, but also other evidence and other order passed in the earlier suit, may be taken up as a preliminary issue or at the final hearing. So, Order 14 or final hearing. But the said question can be determined. This is my point. It is one thing to say that the averments in the plaint on their face discloses no cause of action. That's prayer B, Millard. The averments made on the basis of, if Millard, I put it in this way, our Supreme Court is saying, discloses no cause of action. But it is another thing to say, although the same disclosure is same is barred by law. The decision rendered by this court, also by various high courts, are not uniform in this, but then broad principles which can be curled out therefrom is that a court at this stage would not consider any evidence or enter into any disputed question of fact in the event the jurisdiction of court is found to be barred by law. There are many subject matter thereof. The application for rejection of plaint should be entertained. So subject matter has to be seen from the praise of the plaint. Now, where is the bar in law in filing a suit for declaration that some MOU which is unregistered, unstamped, unenforceable, I am not agreeing to that. It's Millard should be declared void, inoperative, not binding on the plaintiff. Where is the bar? Section 34 permits that. In aid of that prayer, Millard, I can have a Millard consequential prayer, Millard, under Section 38 of the specifically effect of perpetual injunction.
That is not barred.
It's not barred. This is what Millard it says, Millard. If your Lordship, Millard, kindly takes.
At least you, according to you, it's not prima facie a case of rejection of.
Yes. Now, Millard, the next.
Barred, whether your relief will be finally granted or not. Separate.
That's a separate issue. Millard, this is a ploy, Millard. Kindly, Millard, appreciate. This is a ploy, Millard, to Millard just escape the filing of the rigors of the written statement. Because today he'll be tested if the written statement is allowed to be, after 17 years or Millard, after 26, Lordship will pose a question. Why haven't you done so? So the best option is, Millard, push the application for Order 7, Rule 11.
Next.
Now, Millard, kindly now takes Millard 2021 9 SCC page 99. আপনার কাছে রাখুন. This is Millard 2021 9 SCC page 99. Lordship will kindly have a look at paragraph 17, 18. Because exactly what Lordship is saying, res judicata doesn't, my lord, apply in this proceedings, my lord. This is a more detailed one, my lord.
No, my point is not application of res judicata. There may be res judicata.
Yes.
Not in course of order 711 hearing.
Absolutely. Absolutely.
That
And the
is the
first
book of
question I have
law here.
answered. And
Stated.
the first question, my lord, what fell from the lead, how a division bench order, my lord, can be, my lord, challenged in the suit, that I have answered, my lord. I have showed, my lord, 96.3. There are authorities, my lord, from 1955. Even, my lord, a decree which is held to be inoperative can be set up, my lord, in the execution.
Adjudication of the plea of res judicata request, what I have just stated.
Yes. Absolutely.
Request consideration of the pleading issues decision in the previous suit.
Yes.
Such a plea will be beyond scope of order 7.
This is exactly, my lord. I need not place the judgments in detail. These are, my lord,
You give the judgments, I'll go through it.
Yes. Now, my lord, also,
And partial rejection of plaint.
and my lord, partial rejection of plaint. If lordship wants a judgment, I'll cite. It is settled, lord, that the plaint cannot be partially rejected, my lord. This is Shukhanna holding is there. There are others, my lord, right from 70s, my lord. I don't think, my lord, these are necessary to be cited, my lord. Lordship will go through my plaint once, my lord, and see, my lord, whether, my lord,
You give the compilation.
I'll give the compilation. Now, my lord, on my lord, the question, my lord, two other things which I want to put from my supplementary affidavit which I filed in court. This is very important. Very, very important. In all fairness, my lord, this should have been told to the court, my lord. Supplementary affidavit একটা এরকম দিয়েছি ভলিউম 1টাই দিন আমাকে তো একটাই ভলিউম করে দিয়েছে তোমার সাপ্লিটা তোমার সাপ্লি
Yes.
Kindly have, my lord, two things, my lord, I just want to place. Kindly have a look at this has a clearer copy than the plaint. So, my lord, I gave it to your lordship. Kindly have a look at page 27 of my supplementary affidavit. This is what the prayer B relates to. My lord, I pray, my lord, this, my lord, deals with immovable property. This is, my lord, order of, my lord, 15th of September 1993. Then, my lord, 14th of October 1993. Then 17th of December 1993. These are the orders which have been challenged in the suit. I have given a fair copy. Lordship can take it from me. All the orders, my lord, relates to, my lord, at least the first order relates to, my lord, immovable property at, my lord, Rington Street, Park Street, as well as the other immovable properties in Shiliguri and Jalpaiguri. So, my lord, this is a squarely, my lord, is, my lord, our order, my lord, encompasses with itself, my lord, rights arising out of an immovable property. So it has to be stand, my lord, under the provisions of the Stamp Act. If it is not stand, my lord, no one can enforce it. If you cannot execute it or enforce it on the ground of stamping and registration, my lord, where is the question, my lord, of, my lord, arguing a res judicata or a point because of prayer D, single judge will not grant, division bench will not grant. Suppose, my lord, a specific performance suit, my lord, my lord, on a admission is gone through. My lord, if it is not tendered in evidence, we may say, my lord, tendered in evidence, my lord, it is exhibited in the box. If someone doesn't take an exception, my lord, that, my lord, goes through, my lord, an exhibit. Stamping point you cannot take. But it is not such a case here. It's a case, my lord, where the court, my lord, decides to divide the property on the basis of, my lord, the understanding between the parties, which is not stamp registered. Even no party did not get it. Parties, my lord, did not bother to get the decree, which culminated up ultimately, that is 22nd of May 1997, page 34. That's Justice Rumapal and Justice Devendra Kumar Jain. My lord, this is, my lord, deals with fully with an immovable property. And this is subsequent to the suit. This has no bearing for dismissal of my suit. That two prayers, three orders, are, my lord, culminates into this particular decree. Let us put in this way.
Point is that an unstamped document,
yes,
may be admissible, may not be admissible, whatever that might be, that is a naughty question to be decided here.
Here, absolutely. It's not a question. When, my lord, the suit comes, lordship will
That
decide.
can be gone into.
Yes, Section 33, 35, 33 read with section 35 of the Stamp Act,
All these
section
things can
17
be
of the
done.
Registration Act. How, my lord, this can be an issue, my lord, or a genesis of a plaint to be filed. Now, my lord, just one document I want to show, my lord. This very, all fairness, my lord, when you come to the court, you should come with clean hands. Now, my lord, kindly take, my lord, the SLP going from justice, page 202, second volume. Application. The application is by Mr. Binod Kumar Agarwal, who was respondent number 1 in the appeal. This is the Millard array of parties in an SLP, civil special leave petition civil 15619 of 1999. Binod Kumar Agarwal, respondent number 1, petitioner before this court. So, Millard, he challenges what, Millard? The order of, Millard, the decree passed by Honorable Justice Pal and Devendra Kumar Jain. Kindly take, Millard, page 209. He has challenged it. Ground number C. For that the Honorable Court failed to appreciate in the case that the said incorporation of the list of properties was not allowed, the decree dated 22/5/1997, which has in fact been upheld by the Honorable Supreme Court, would also be rendered.
Cannot consider all these things because all these are extraneous.
And Millard, there's a subsequent, and the SLP was dismissed at page 246. Lordship will take it, Millard. Where is the decree in law?
All right, you file all your judgments.
And the bench presided by Justice Arindam Mukherjee and Justice Somadar have held so at page 293.
We cannot consider this.
Absolutely. And Millard, both parties rely on 2021 9 SCC page 99. Principles of res judicata, I am answering a law point. Both the judgment in no unequivocal terms says, Millard, res judicata is not a factor to be decided, Millard, in an order 7/2011. So, Millard, I file a 2-page note with the compilation to your lordship.
All right.
You reply.
Well, one day, my lord, grants me one day, my lord, I should reply.
Keeps it next week, Millard.
Heard in part. The learned counsel appearing for the petitioner defendant prays for accommodation to make reply. Let the matter appear in the list on. কবে একটা ডেট দেখো তো কম আছে কবে 18 দেখো তো
পার্শিয়াল রিজেকশন হবে না, ওদের যদি এক্সট্রা কিছু থাকে ওকে দিয়ে একদিনের মধ্যে।
You have couple of points to reply.
And if I find, Millard, anything more on that, whether sitting singly, Millard, I'll indicate to my learned friend.
Because we have to reply on those
Well,
points.
he has completed his submissions. Well, we shall reply on
He has complete submission. He will only find notes of argument.
পরের দিন যদি পাই কিছু
কোথাও ওই ডেটটা দেখো কবে করব
কবে
18th of September. Grateful, my lord.
Grateful, much obliged.
Item 23. Your Lordship, I am appearing for the applicant, defendant number 4, madam. Defendant number 24.
I appear for the rest of the defendants.
Mr. Chaudhary, you are appearing for?
The plaintiff. He is opposing the application.
Matter has been disposed of. Application will kindly see the petition. Petition, no?
My lord, the point was raised was limitation.
Yes.
Today I have to answer on that. Let me start.
What GA 14 and 15 are about?
GA 14, my lord.
Lord, kindly take, I'll just take 1 minute.
Who has filed this application?
I have filed. My lord,
he's argued.
So I will hear you first. Let me hear his point.
Lordship, the point they take, their first main point of defense was
not their point. You have filed this application.
My application was moved. Mr. Shortkar was leading me at that point of time. He had moved the application. They had raised a point of limitation. They had made their submission on limitation.
What application?
My lord, my application is for setting aside of a decree compromise decree on the ground of fraud.
I have a, my lord, just to remind your lordship, my lord. This is, my lord, GA number 14 is a combined application containing, my lord, a prayer for condonation of delay and for setting
Okay, I
aside.
understand now.
Yes,
That question he later
Yes, he has to get
realized
over
that
the-
valuation is less
Yeah.
his valuation is less.
For
He has to, my lord,
and he has to face income tax wrap, income tax.
that's what he
liability.
says, my lord. Now, the point is, my lord, to have your lordship, my lord, set aside a decree on consent which has been passed, my lord, on 11th December 2015 after 8 years. He has to first explain delay. I, my lord, showed your lordship that delay, my lord, applies. He's also conscious of that position, which is why he's made a prayer for condonation. In the petition, there is no, my lord, explanation for the delay. That's, my lord, my submission. He, my lord, has to open the gate first by, my lord, making his, my lord, case on.
I can remember it now.
Yes.
What else new? What new thing will you
My
plead?
lord, I have to answer first on his limitation point, then I'll go into the merits.
Mr. Sarkar stated that there is no limitation in this case. Refer to section 12 or 13 of the Trust Act.
10 and
So
10
that is
and
answered.
10 of the Limitation Act and also section 18 of 17 or 18 of the. May I?
These are replied by Mr. Sarkar.
No, my lord. Mr. Sarkar gave that pass, then they replied, my lord, I now answer to their point of limitation. My first point here is, my lord, your lordship is well aware, limitation is not a pure question of fact. It is a pure question of law. It's a question of fact and law. So I must plead, they must deny. Now, if your lordship kindly comes to paragraph, my first, they have showed the prayer, my lord. They have showed
Said it came to your notice later on in 19.
Lordship kindly allows me to place according to my. My lord, if your lordship kindly takes paragraph 17 of my application at page 21. What is my positive case? This is the paragraph. If your lordship comes to paragraph 22, page 22, the first portion, application.
Page
GA
20.
14.
Page 20.
Page 22, my lord. I'm on page 22.
Page 22.
Page 22 of GA 14, paragraph 17, last portion.
Page 22 of your application.
My application, GA 14.
Yes.
Just before paragraph 18 starts, my lord.
No part of the defendant's claim.
Claim made in the application is barred by the laws of limitation.
Yes,
But
that was submitted. I can remember.
I understand, my lord. This is my case. And another was that there was a fraud. The allegations on fraud and the issues of fraud are set out in paragraph 15 of my application. The question of me answering on all this point will first arise if they have denied my statements.
No, what is my learning?
My lord,
let him submit. Chaudhary, let him submit.
My lord, if they have denied my allegation statement that there is no, sorry, you are wrong. It was barred by limitation. Whether limitation and there was no fraud. Is it Mr. Chaudhary has denied that in his affidavit? First, lordship, your lordship takes up his affidavit now. The last occasion it was filed. Well, I showed paragraph 17 of the application. If your lordship now comes to their affidavit in opposition. Of the respondent number 1, the plaintiff. It was filed on the last occasion. Plaintiff this.
Brij Chandra Agarwal.
No. Sunil Agarwal.
What GA15 is about?
GA15 is a new application, probably has been filed. My lord, it has not yet been served. It's about, probably I am not aware, my lord, maybe some application. I'm not aware, my lord. GA14, there was an.
Your application?
No. It's somebody else's application. I don't know.
GA15?
Service code is
It is an application for.
Oh, stay. It is an application for stay, my lord.
Stay and injunction.
So today that is the plain application is here being heard now, my lord. That is the application for stay. OTA GA15.
Lord, may I just to put it in the right perspective, not just one sentence. My learned friend's case is that
There is
Mr.
no.
Chaudhary, when he is making submission.
No, I'll just remind you, Lordship, the argument was that there is no bar of limitation.
I can
So, Milord,
remember
he has
still
to
now.
I've cited two judgments. He has to first answer that.
My lord, I will first answer on his facts. Limitation.
Where is the supplementary affidavit?
Where is the affidavit? My lord, their affidavit. Sunil Kumar Agarwal. Sunil Kumar Agarwal. GA15 টা তো GA15 তো এই তো
হ্যাঁ GA15
তাহলে সাপ্লিমেন্টারি বলিনি তো না সাপ্লিমেন্টারি না the affidavit in opposition of Sunil Agarwal. One plaintiff Sunil Kumar Agarwal. তোর অ্যাডভোকেট নগর কে রে?
আমার
এসকে সিং না তাম Shabarmai Ghosh, yes. Lordship, I placed paragraph 17. Lordship, I placed paragraph 17. I placed paragraph 17. Now your lordship kindly takes their paragraph 10.
Paragraph 10?
Yes, at page 21. Paragraph 9 deals with paragraph 15. Paragraph 10 deals with there is no denial that there was fraud. There is no denial that is not barred by limitation. And secondly, my lord, whether your lordship will look into this affidavit also is a question, because as far as the copy supplied to us, my lord, the jural portion is empty. The lordship kindly takes to paragraph
14 is hopelessly barred by limitation.
My lord, page 14 is hopelessly now where my allegation is made, must it be dealt with, my lord?
Might be, but section 13 he has made specific amendment that hopelessly barred by limitation.
Now, my lordship kindly comes to page 24 once, whether your lordship will look into it.
24.
The jural, page 24, the jural portion, my lord, it has to be rectified before he even opens his mouth. It is empty. At least in the copy supplied to us, it was empty.
Which part?
The jural portion, paragraph 24, 22.
22?
Yes.
Which part you are referring to?
The statements made in paragraphs blank to blank are true to my knowledge, and the rest of my humble submission. What is true to knowledge? This has to be rectified, my lord.
Yes.
In affidavit in opposition.
Page 24, paragraph 22.
Yes.
Where is the Jumar that has to be rectified?
What is this, Mr. Chaudhary?
Three submissions. One is the notary, my lord, should lose his right to conduct further, my lord, acts.
Why do victimizing the notary?
He's supposed to see this at least.
That's why.
Number two, my lord,
no, he is supposed to put a stamp. He has already put a stamp on it.
No, he's supposed to see this and then put the stamp.
Why he will not put the stamp? It is not his duty to look whether you have left something blank or not.
Then the advocate, my lord, should be severely reprimanded for doing this.
Mr. Agarwal sign it.
These are not supposed to.
Because notary is not supposed to fill in the blanks.
No. Without an affidavit, paragraphs being put in, notary, advocate should have refused to do it. Notary
advocate should do.
Done. This is
let it be rectified. Supplementary, let it be rectified.
It has to be this affidavit is of no meaning.
And it is filed before this court.
Yes. It is of no meaning. Cannot be relied upon by a party. This is contrary to order 19 of the Civil Procedure Code. Yes. No, that doesn't change matters. I am your lordship's officer. I have to file an affidavit.
Solemnly affirmed in the courthouse in Calcutta on gap date.
No, that is there on the 22nd February. That is the notary.
That is a stamp of notary.
Notary.
How can it be done in the courthouse?
Is format done it?
That I'll have to file an affidavit.
You have to withdraw it. Simply withdraw it.
Yes, I'll withdraw it.
Would you withdraw today or some other day?
Yeah, other day, my lord, kindly keep it and kindly give me leave to, my lord, withdraw this
You
affidavit.
come on, I will give you leave. Adjourn to. Very sad, very sad.
Very sad state of affairs.
Because the senior lawyers are embarrassed.
No, it is very
Council, so
sad,
this is
my lord.
embarrassment for the councils. An advantage to you.
He will take that, he knows me, I know him. So that is not.
14th September?
Yes.
Of course.
Great.
Item 24.
Well, in this matter, your lordship has been pleased to pass an order asking the learned commissioner and receiver to be present. Well, I am appearing for him the report and to file a report. Mr. Mondal is the receiver. Well, may he file the report first. I don't know who are the.
Your Lordship, Mr. Bimlendu Das is appearing for defendant number 2A. In
Report of the
CS
partition
87.
commissioner shall be filed on 31st August.
Yes. And your lordship
Now it's today filed.
asked him to be present. He is there. What has happened is Mr. Das
Is very
is
ill. Your
very
Lordship.
ill. So there's a conveyance. The payment has been received, is kept in the bank by the receiver. The conveyance has to be executed. Now that is taking a lot of time because the original papers, etc. And Mr. Bimalendu Das was to do it, but he's been
Very ill.
ill on and off.
If you could, Lordship could take up the matter in the November, in the list of November, then the deeds cannot be executed, Your Lordship. 3
Should it be
deeds.
November or should the receiver be substituted?
No, he's been there from 93, no remuneration also. I've asked.
I've paid any
No, there's-
remuneration?
He's been appointed long, but that is later. He wants to finish the duty that way. One was sold, 19 sold now. One building has been sold as a partition, so 3 of them, the auction has been happened. The money is also come in. Only the conveyance has to be executed. And that money he'll be
Report of the
discharged.
partition commissioner.
No, this is the report. Your lordship keeps it in November. I think by that time it will be done, maybe if it is done.
On prayer of the learned council for
But I appear for the learned receiver. Your lordship will record that Mr. Mondal is present and he has filed his report. And you are for which defendant?
learned
CS
receiver is present
887.
today with the report.
Receiver stroke commissioner of partition.
Yes, receiver stroke commissioner of partition.
Last paragraph, my lord will see.
Why interim report?
Because it's not been sold, the properties. The final report will be when the partition happens. Paragraph 39, if my lord sees, this is the last, what is,
The properties are there. What is the description of the properties?
there are 3 properties which they've been agreed to be sold. The auction is done.
Total properties, some are sold possibly.
Total for that. All are being sold.
How many properties are there within?
The last 3 are being sold.
How many properties are involved in
My
this?
lord, paragraph 28, 3 properties are left. One was already
All are sold.
One is sold, 3 are left. Now the sale has been completed, but the conveyances have not been done. Paragraph 28. Those are the 3.
Revival of the current account. Premature encashment of term deposit.
Yes, then your lordship will see the 3 immovable properties.
And sale of premises 70A Beniatola Street.
70A, 148, and the 2 shop rooms on Old China Bazaar Street. Then, my lord, there was an application. And this is to be sold now.
Current account was revived.
Yes. Paragraph 36, my lord, the
Where have
successful.
you mentioned that these three properties are only left out?
And paragraph 36 says that these are the successful bidders. The
No, not
properties will
successful
appear
bidders.
from the plaint, my lord. We don't have.
Not successful bidders. Only these three properties are left out. Names of successful bidders are there, expenses, so and so.
But it's there at the beginning where he stated the facts of the suit. These are the three properties. These conveyances were missing. Then they've got certified copies in the month of May.
Preliminary decree was passed.
Yes, long time, 75.
July 75.
Yes. Once the conveyances are done, then the money will be distributed and hopefully the matter will finally see its 1965 suit.
You mentioned 1 to 4. 4 was earlier sold.
Paragraph 35. No, 35 is these three. Then paragraph 22, 12 Raja Raj Vallabh Street was already sold in terms of the order in 1975. Paragraph 22 is the fourth property.
That consideration money was 1,38,500. That was put in fixed deposit.
Yes.
And now it is 12,59,232.
That was the encashment, right? It was 15
At the
lakh.
time of encashment, it stood at so. Which was supposed to yield 15,37,007 on maturity.
Then the municipal taxes, I think, were paid.
Now these premises are to be sold.
They have been sold pursuant to orders of court. 39, if my lord comes, what is left to be done is the conveyances have to be executed.
Where are the parties, other parties? You are for?
I'm for your lordship, Mr. Bimlindu Das appearing for defendant number 2A in CS
Have you
887.
served this report to the parties?
No, but your lordship has directed us to give. This need not
Done
be
it.
given to them. Let them come and say what they want. He has to do. Our duty is to court, my lord.
The learned advocate commissioner of the receiver is present today and submitted signed pages, all the pages. His report bearing date, लिख नहीं था ना? Date. ওইটা দেখ, ওইটা আমাদের কি issue করতে দেখি। হ্যাঁ? 31st August 23. 23.
Initial.
A copies of the report may be given to the parties for their perusal. Let the matter appear in the list, comma, as submitted by the learned counsel for the receiver.
No, by counsel for 2A.
2A. Defendant number 2A.
On 23rd November. Is it okay? 23rd November? 23rd November.
Great.
For consideration on the learned advocate commissioner, partition commissioner's report.
If it is sold by then, they will come and give the report. It's only the formal Mr. Das is. Let it be on that day will come.
On full stop. If the property is sold, the learned advocate commissioner shall submit further report in this regard.
Great. Great.
Much okay.
Item 26 and 27.
Lord, item 26 and 27. 26 is my suit, my lord. I am for the plaintiff. 27, I am for the defendant.
Have you filed some application?
No, my lord. Let me just, my lord, clarify the position. My lord, if your lordship takes the last order, my lord, we had informed, as far as Mr. Ghosh's suit is concerned, certain defendants died. My lord, so we were requested by Mr. Ghosh's client to give the names of the heirs of the defendants, my lord. My lord, today I appear on behalf of the partnership firm, my lord. The other defendants have been arrayed by Mr. Ghosh's client in the suit. My lord, I tried. My endeavor was to take the heir's name and present the names to the advocate of Mr. Ghosh. My lord, but I have tried. I have not found the names of the heirs of defendant numbers 2, 3, 4, and 8. And as such, I wrote a letter to Mr. Ghosh's client on 14th August 2023, whereby I have clarified, my lord, that please be informed that my client, being a partnership firm, is not aware about the particulars of the legal heirs of the deceased defendants. But it is not possible for the defendant number 1 partnership firm to come to know about the heirs of the other defendants who have died, my lord. We had ascertained they have died, but my lord, the heirs we have not been able to. That is the situation as far as Mr. Ghosh's suit is concerned.
In my suit, we are saying this is a partnership, is not a registered partnership firm. So all the partners were made parties, 1 to 8, and they have filed a joint written statement. Then, my lord, when the suit is coming up for final hearing, then there are 2 suits, one by the partnership firm. They have claimed to be a registered firm. We've taken the point that they are not registered. They could not prove it. So the suit is not maintainable. Now, when the partners died, the partnership deed says that their heirs are entitled to become partners. We don't know what happened there. But my lord, the new partners, they're all new people. They have given their names. They said, you substitute us. But my lord, I have to serve, then I will serve. Since they only informed us, no, the other defendants haven't informed us. 2, 3, 4, and 8, according to them, have died. No date of death has been given to us. No heirs have been given to us. So lordship will allow us to serve it again and let it come back as deceased. Then we will find, because my learned friend's information is incomplete. They just say it's dead and they've tried and they have not.
You can do one thing if necessary. If they died within Calcutta Municipal Corporation area, I can ask them to produce the death certificates.
Yes.
That you have to file a supplementary affidavit stating where they died.
Only legal heirs usually can get the certificate. Yes, your lordship can direct.
Can direct them.
So your lordship will permit.
In one case, I have directed, and I've heard the copy of the death certificate is handed over.
Lord, that I suppose would solve the issue.
Then, my lord, first.
Now, if no legal heirs are found, the suit will abate against them.
No, as far as the present partners, they are probably liable.
Lord, that is what
they are volunteering.
Yes.
So your lordship will give us till November. I'll ask them to serve at the addresses.
You do one thing, you file a supplementary affidavit stating where they died. That is important.
Neither do we know, my lord. That is the difficulty.
My lord, we will give us liberty, my lord, the plaintiff in one of these suits, the ICICI Bank, to serve
notices on the defendants. Then let it come back as the addresses that we have. Then once if it is ascertained that they have deceased, then my lord, I'll take steps. And in the meantime, I can make them.
Passing adjournment order.
Yes.
Come, when will you be able to come?
In October, your lordship will keep it.
On prayer of the councils of for the parties.
October. Let it be after the vacation, because they'll have to at least add this.
Adjourned to 24th November.
Great.
My lord, may I make one innocuous prayer, my lord, on Mr. Bagadia's submission on the last order, 19 July 2023. My lord, Mr. Shubhashish Sengupta and myself were appearing along with Mr. Bagadia, but the recording has not gone down. I'll just provide the names if your lordship allows. On the last order. No.
The order dated 19 July 2023 is rectified to the extent. Give the name.
Yes.
The such and such names shall be inserted as a learned counsel of the defendant. For defendant
number 1.
Defendant number 1. Let the rectification be carried out in uploaded order.
Deeply obliged.
Grateful.
Item 28. On a project.
I appear for the plaintiff petitioner, my lord. I filed an application for carrying out, my lord, the change in name of the defendant number 3, my lord. The defendant number 3, when the suit was filed, was United Bank of India. So now
that we discussed.
Yes, that has become Punjab National Bank now. Only that change.
Where is that application? That is GA number 11.
13, my lord.
13. 14, 13, 13, 13. 13, na? 13. Amendment application.
13.
Master summons.
Lordship will find, my lord,
Have you any objection? Who is the other side?
To deputy number 2, my lord. There's no objection.
No objection.
Beyond limitation, my lord.
in change
No,
of
it
name.
isn't change of name.
Change of name.
GA number 13 of 23 is filed with a prayer to change the name of defendant number 3 in view of amalgamation of the existing United Bank of India to Punjab National Bank. Prayer A2, C of the master summons are allowed. Let the matter appear in the list on 29 September.
Lord, may I pray for one more indulgence? My lord, the summons with regard to the amended plaint may be dispensed with, my lord, upon serving a copy of the cost.
Summons of the amended plaint may be served personally to the learned counsel of the for the adversaries, for the defendants.
And the serving of the fresh writ of summons may be dispensed with.
Fresh set of summons, service of fresh set of summons may be dispensed with.
I'm so grateful.
Disposed of. $29.
9.
My lord, I do appear for the plaintiff. 2007 eviction suit. 4 floors at Kamak Street, Gagantara building was given initially to the defense estate Union of India, there was an agreement for a limited period of 2 years with an option
Who
for
is your other side? Who is for Union of India?
Mr. Singhania was appearing. Mr. Dashgupta was appearing. There's a catena of lawyers they have
I
hired.
have heard it.
Yes, my lord has heard it. Now, I say, my learned sister is there. Now, my lord. 2007, I issued a one GA, that's a GA for a summary judgment, 2007 GA. Suit under the Transfer of Property Act.
Chapter 13A.
Chapter 13A. Old number was.
What is the application?
Is old GA number 1556 of 2007. Now, without troubling your lordship, I will just cut the matter short, my lord.
When it was terminated?
It was terminated in 2006 by a notice.
Have you mentioned that?
31st July 2006. It was terminated. They were asked to vacate the property by 31st of August 2006. And they were said that from 1st September 2006, you will be treated as a trespasser, illegal occupier of the property if you don't act according to the requisition of the notice issued under section 106 of the TP Act. Now there is a development in the matter. My lord is going through the GA1 of 2007. That's chapter 7. Now during the pendants, application was heard for number of times. There are orders to that effect. Now, the development which has happened during the pendency of the suit and the application, they have vacated my property. They have handed over possession. In this regard, I have affirmed a supplementary affidavit disclosing that subsequent event. To cut the matter short, my lord can take note of that and dispose of the prayers A and B, because with regard to decree for eviction and recovery of possession, since I have got possession of the property, my lord will take note of the 2 dates, because on 2 dates they handed over. It was 4 floors, 2 floors on one day, another 2 floors on another day. My lord will take note of that dates and can dispose of these 2 prayers. Because with regard to prayer A and B was a final judgment and decree be passed directing the defendants and each of them to deliver.
Portion remains main profit.
Only the mean profit. Now, here also, pursuant to an order passed by this honorable court, a special referee was appointed. He has done the exercise. He has submitted a report. He has determined a mean profit.
That one.
That one. Only they have challenged it. They have taken exception. That's the second part. First part, my lord, prayers A and B can be disposed of. Because since they have already handed over possession, that is not a disputed fact.
Master Summons kothay?
Yes. Here A and B of that application can be disposed of. 2007.
Where is your supplementary affidavit?
My lord, a supplementary affidavit is on the 25th of August 2023. Ayyo. Copy is down. We have filed it in the department, may not has come before, my lord. This is, we have a copy, my lord. We have served them.
I'm
also.
fixing it tomorrow. Come tomorrow then.
Yes, my lord.
Not today.
Well, tomorrow, my lord, may have some problem.
Day after tomorrow?
My lord, the supplementary affidavit.
No, do tarik so Friday, Saturday. 2 tarik. 4th, my lord.
4th. Adjourn to 4th September.
Because, my lord, since I thought because unnecessary.
No, it should not be dragged.
Because 2 of the prayers today becomes, my lord, once they have handed over, I have got
No,
position.
Mr. Dasgupta, you have to argue 2 things.
My lord.
Because first and second prayer are infractuous right now.
My lord.
We have already delivered position. Issue is main profit. Whether fresh appointment will be made or that earlier one will continue or relied upon.
Fresh appointment.
Advocate or commissioner or special
My
officer
lord.
for main profit.
My lord.
One was already done, one exercise. Whether that is to be considered or it will continue.
My lord, the issue whether the decree, the possession on the termination was legal or not, and whether it has not been void.
No, you have already.
No. My lord, the issue gains significance because of one reason, my lord. Their direction was passed to calculate mean profit. The mean profit presumes that there is a starting date of illegal occupation. That date is very significant because, my lord, there was a particular system of arbitration going on in 2 phases. In first phase, that went on very long, even after they used served.
Even then, whether it is unlawful, whether it's lawful, authorized, unauthorized, question of delivery of position no longer exists right now.
Yes, that is the
question
point.
of delivery position no
So
longer.
that can be considered at the time of hearing on main profit.
Yes.
That is also not issue. Issue is whether one advocate commissioner was appointed.
Yes.
Whether that report will continue or fresh is to be appointed.
That will be decided once the first 2 prayers are dealt with, my lord. They have taken an exception to that
My lord,
report.
before a decree is not
Cannot-
passed.
I
That
cannot.
is the issue.
But that has been done, my lord, by the blessings of the order of a pass by this.
Blessings of you.
No. I can't give blessings, my lord. I can only take blessings, only seek blessings.
So a decree of
Basically,
it
one
cannot
issue
be
is
done
there.
in the chapter
No,
13.
right. One issue is there. Same exercise is to be done again. It will take time.
Right.
So this may be taken right now
My lord,
and as if it is passed after the decree.
Yes. That
It
is
is now accepted and to be deemed to be passed after the decree.
yes, that is correct, my lord. Absolutely correct.
Because it will take expense also.
I understand, my lord. The issue gains very significance. I will place it on the
That
next page.
yes,
I will
that
show
time.
that.
So we have to accept this. We have to accept this in the sense we have to act upon this report, and now we will decide whether there is unauthorized possession, whether the exact rent is the calculation is correct or not. All these things,
Yes.
all these relevant issues.
Right.
But basic question is
Whether these issues can be now decided in the existing chapter 13. my lord.
But chapter 13, the first 2
infrastructure.
prayers, my lord, because since they have delivered possession to me, I have gone.
Chapter 13 has a particular purpose under the original site
chapter,
rules.
even it is not chapter 13 application, since delivery of possession is made, it will be around 20 rule 12.
Yes.
Whether chapter 13 basic thing is whether you are delivering the possession. Since delivery of possession is done, that part is redundant. So without passing any order for delivery of possession formally, let this accept this. Further, without doing any further
Subject to my explaining, your lordship, the problem in this issue.
to file exception to this. Have you
No,
filed?
not exception. That issue, that particular, there is an overlapping period when termination notice has been issued, but they have claimed
You argue
about
that at the time of hearing.
yes. That is the only issue that will decide everything else, my lord.
All right, that you argue.
Well,
But we shall start argument on the basis of this report.
very well.
You file exception.
They have already filed their exception.
That's all. Then we'll fix argument for this.
Right.
Come forth.
I understand.
Matter will be expedited.
Yes, my lord. That's why, my lord, I indicated the first instance. There is a subsequent development. Let the court take notice of this and can dispose of the first 2 prayers.
Item 30. MAJUMDAR Mullik.
First 2 prayers.
Your application for injunction.
My application for injunction is also there. Their application for substitution is also there.
Substitution should be done.
Yes, I have filed the substitution application.
Have you got copy?
And I've got copy, my lord. I'm not opposing that application. I have nothing to oppose.
2020, GA20.
GA20.
Master Samonstar. GA number
20.
20 of 23 is filed with a prayer for substitution in view of death of defendant number 3, Asma Malik. Full stop. Neither of the parties made any objection. Let prayer A and B be allowed. Department, full stop. Department is directed to do the needful. GA 20 of 23 stands disposed of. So it is for GA 18.
GA 18, my lord.
Other applications are pending.
Only GA 18 is pending, my lord.
18,
Fixed. Now, 28th September for hearing of GA 18.
27th, money.
20. Kuri.
Acha. Okay.
What about the application for passing preliminary decree? Preliminary decree was passed.
Degree was passed and they have filed the review application on that basis. But the review preliminary degree passed already, my lord. And already passed and on their.
Now partition commissioner is to be appointed for.
Yes,
my lord.
Appointed. Already appointed.
My lord. But one of the parties has just died, and one party had died before this. But this is Muslim succession will apply when it comes to this property, my lord. So the
All right, partition commissioner is already there.
Yes.
He will adjust the shares. He will reconsider the shares, allotment of shares.
If it is actually needed, my lord.
But if it has to be part of the preliminary decree subject to correction by your lord.
That is already
Not necessary.
decided, my lord, and found by the appeal court. In the appeal court, they have preferred a review.
Subsequent events that can be adjusted in final decree. Why preliminary decree will be changed?
But the
Preliminary
shares has to be adjudicated. Probably
There is no dispute about
the shares
that will be passed in the final decree. Why that will be preliminary decree will be once again changed.
But
Partition commissioner,
my lord, it is my lord will kindly hear me out for
let
once.
the report of partition commissioner come. Partition commissioner,
My lord, on an earlier occasion, my lord had considered this and had specifically passed an order.
consider the subsequent development of events, namely death of the parties and devolution of their interest in preparation of the report.
But,
Once that report will be filed, will pass final decree.
Your lordship was pleased to appoint, my lord, all the awards as joint partition commissioner.
Yes.
My lord, we have filed a report in the meeting, my lord. They are
No, subsequent, because of subsequent change in the circumstances,
we shall
share
find,
have to
my
be
lord.
readjusted.
our shares have to be adjudicated, my lord, subject to correction, my lord.
If you agree upon the shares, why adjudication will be there?
No, we are, it is not about
Let a
us
report
agreeing,
come.
it is about them disagreeing.
Let a report come.
there is
None can
the
disagree
report,
about
my
your
lord,
extent of right.
My lord will
None can disagree on the extent of your right.
my lord.
So if your share is up to 20%, none can say it will be 15% or 25%.
What has happened, my lord, in this the two.
Let the report come.
The report should come, but in the meantime, my building is being demolished. It's sought to be demolished. There's a resolution by two of the partition commissioners.
All right, that's why I'm fixing date of hearing.
My lord, that is another concern, my lord. It's in a dilapidated condition, my lord.
Then that is to be done.
My lord.
There are judgments of this honorable court. It was before Honorable Justice Amrita Sinha in regard to the building being dilapidated.
At the time of hearing, this is the issue.
My lord, in the
120.
My
Actually, it turns out to be so necessary steps will be taken.
My lord, the only thing, my lord, if the partition commission has to file a final report, let my building not be demolished in the meantime. If the building is demolished, everything goes.
If there is order of demolition, have you filed anything?
But there is
Have
no
you filed AO?
order of demolition. In fact, Honorable Justice
my lord,
Amrita Sinha was of the opinion that
We have
they
filed
filed
it.
AO.
Yes, sir. If it is in opposition, we have already filed.
In
In that application, G18.
Have you mentioned all these things?
Yes, my lord. This is on the.
কবে vote date?
G18.
My lord of
Come on that
was
date,
of
I will hear.
20th.
20th September.
But my lord, in my humble submission, since the papers are not before your lordship,
Then, my lord,
today, my lord,
Kolkata
fix
Municipal Corporation have to be
any date, my lord, I'll satisfy your lordship thereafter. if
Yes,
my lord-
20th September, I have fixed it.
My lord, the only thing my lord has said that the joint commission of partitions will decide everything, my lord. That is the only thing. If it
not
can be,
decide,
can
file a
be
report.
kept
Have I
to-
said that? Have you heard me?
I bow down to your lordship. But the joint commission of partitions.
They will submit a report. How can they adjudicate?
If they are not adjudicating, my lord, I bow down.
How they can adjudicate? How can you think that?
But they may not.
Work, please have your brain work.
But I bow down to your lordship.
They will submit a report. They will ascertain who will get how much.
That is what I was submitting, that the court has to decide, not
Yes.
joint commission of
The
partitions.
final decree, when the final decree will be passed,
My-
preliminary decree will not be changed.
I bow down to, I apologize to my lord. I understood.
Use your head. Next,
Old suits, item number 35.
old suits কালকে আনো।
I'm praying for some time, my lord, as the
Tomorrow.
plaintiff number one has died, my lord, and substitution
Very good.
application has to be
35
taken.
to 38 tomorrow. আজকে শোয়া
My lord may adjourn it to some other date, my lord, that is the thing. But substitution application has to be
all
taken out.
these old suit matters will be not today, come tomorrow.
for arguments.
Yes.
I know 31.
Well, as usual, the other side is not here. We have filed our notes. They are supposed to give us.
Let me wait. Let me here take up other matters.
Orders, my lord, can, because they had to file the notes, my lord. We are, has fallen from my lord, my lord, that the matter should come.
Let me see the judgment. Single bench and division bench. Give me single bench judgment first.
Three 41 of the paper has got it. 341 of the paper.
Where is the judgment?
341 of the paper book, my lord. Paper book, my lord, has got it. It's
Paper
easier.
book?
Yes.
No, you have given a compilation.
No, compilation will not have this because it is whatever is there in the paper book has not been given in the compilation. Paper book.
341.
341.
No issues are framed regarding maintainability of the suit.
No, it was framed. Malad has himself found out at page 347.
Subsequently, these issues were framed.
Yes.
9 is the maintainability issue.
9 is the maintainability.
What was the finding in respect of 9?
9 is negative. 9 we have lost. Kindly come to page 377. I answered the issues in the following manner. I answer issue number 2 in the negative. So far as issue number 7 is concerned, the plaintiff has failed to give any evidence, and as such, the same is negative. The parties did not insist on 8, and no argument was advanced. On the side, I answered issue number 9 in the negative.
Suit was dismissed for as not maintainable, specifically held by the trial court.
Now, since my learned friend has said this, now when the
let me go through it first. Now, what is the order of the division bench?
Now, division bench ordered in the compilation, my lord, second compilation, page 21.
So I have to hear this point, maintainability issue. Because maintainability issue, the very interesting thing is that the trial judge decided the maintainability issue against you.
My lord.
No reason is there, but decided against you. And the appellate court decided that issue number 1 shall be decided first, then other issues. So, what do you have to say on maintainability issue?
Well, if your lordship, my lord, decide that issue, well, my respectful submission is that.
What I shall decide unless I hear you.
No, my lord, what I am submitting, my lord, since the matter was remanded back to the trial court for hearing on the point of only the issue number 1.
No. It was said that once the issue number 1 is decided in favor of the plaintiff,
then other
issue. But basically, if the suit is not otherwise maintainable, then why should I decide this issue?
That is quite good, and my lord. Now, my lord, in that issue, my lord, I am saying, my lord, in fact, today, my lord, we are not ready with the arms and ammunition because I thought written argument will be submitted. Then
it can incorporate in the written argument. Have you given it?
Yes, it has been given, but I want to cite custom seconds.
It is not a question of citing judgment. It's a factual issue.
Yes. Well, fact is there. The show cause notice was issued under Sea Customs Act. On reasonable belief, the officers of the customs, my lord, thought that the goods were smuggled because it was recovered from Bajoria. Then law says, if any goods has been on reasonable belief, the officers seize the goods, then it is duty cast upon the person from whose it was recovered to satisfy the authority that it is either it has been legally imported or it has been otherwise he is the owner or possession of the property. Legally, a person may be, suppose my lord, I am running on the way, I have a mobile, but I don't have any document to prove that this is my.
That is separate thing. Presumption
Same-
is there.
My lord, same
against
thing
for the
is there, my
property.
lord. Here is not a simplicity of one single article. The 620 pieces of 20 pieces of diamond, other jewelry is also there, my lord. Even had it been a case, my lord, single piece or 2-3 pieces,
Say X amount of certain property.
therefore a huge amount of diamonds.
Whether it is huge, whether it is single, that's separate.
Then my lord, question is that once it has been seized, the duty cast upon the person from whom it was seized, my lord, he should.
Two issues are there. Listen carefully. First thing is that certain provisions were there under Sea Customs Act. And that Sea Customs Act is applicable under proceeding under Sea Customs Act.
Lordship.
Here, a third party filed a declaratory suit claiming ownership. That is not barred.
Yes. That is section 9 of the Civil Procedure Code, my lord. It has been categorically stated there. The civil suit can be filed if it has been either expressly or implied barred by the law.
Which law?
According to the Sea Customs Act, it's a complete code. Then, my lord, my lord, may I finish, my lord? Then, my lord, every person, when any customs officer seized any goods, they are seizing the goods on reasonable belief. And the law says that if that goods have been seized, then onus lies upon the person from whom the goods were seized. He is to prove that the goods are not his goods or he is legally owner or whatever it may be. Legality has to be proved. Right to hold the property has to be.
That is separate issue.
No, my lord, I'm coming to that. In that case, my lord, I'm saying, my lord, it's an implied bar of the civil code, my lord, to decide the articles which has been seized by the customs authority, because there is all proceedings are there. Seizure, he can come against seizure, he can come against adjudication or he can come against, there is appellate forum also there. Thereafter, my lord, the tribunal also there. Thereafter, the High Court also there. Sitting
Where
in
is the act?
My lord?
Where is the act? Have you got the copy of the act?
Yeah, I have the God.
It's very bad. Weather outside is.
My lord, it's raining like anything. Well, that's why I couldn't get hold of the brief today. That I thought, my lord.
So no, just outline my points. I'm just outlining my issues. First thing, Sea Customs Act is a complete code. I am assuming your argument as a correct. Now, question is, see what Sea Customs Acts are the provisions of Sea Customs Act. Suppose some properties, X, Y, Z, whatever that might be, these properties were seized on reasonable belief, on assumption, on whatever, or on getting information that these things are illegally imported into India,
Lordship.
violating provisions of Sea Customs Act.
Lordship.
So the person from whom it is seized
Lordship.
is to prove he is innocent or it is legally got so and so.
Lordship.
But so far as, is there any provision that a third person
Lordship.
whose property is seized
Lordship.
cannot claim or is to come only under Sea Customs Act?
But he can challenge the seizure also. The third party, if he can prove that he's the owner of the property, but he could, because the notice of so-called notice not only alone given to the Ramnath Bajuria, thereafter letters have been, galore of the letters have been given to the plaintiffs. Kindly see, these things are going on. He could have wrote a letter to the custom authority. Why you are seizing these things? These goods have belong to me. Kindly appreciate, my lord. It is, had it been a case that the plaintiffs have no knowledge.
So have you incorporated in your notes of argument?
Yes.
All right.
And apart from that, I am saying, my lord,
I am not here about to hear your answer. I am just giving you points which I want clarification.
Lordship.
You put all these things in your notes of argument.
Lordship.
So maintainability point,
Lordship.
maintainability point of this particular suit.
Lordship.
Any person can file a declaratory suit.
Lordship.
There is no bar. There are third persons from whom it is seized or from whom it is not seized. Three persons, not from all persons custody. It was these particles were seized. They are claiming the right proprietorship right in the property. So they can file civil suit.
No, my lord. Supreme Court held in a case, in excise matter in 2015, the judgment I have annexed here, says, my lord, it's an implied bar of the civil code. Civil court cannot decide any issue pertaining to the goods have been seized.
Let me finish my points.
My lord.
These points you must answer in your notes of argument.
Lordship.
I am outlining my points.
Lordship.
That is one thing.
Lordship.
Second thing, this civil suit, even though maintainable, may be barred by limitation.
Lordship.
That also goes to maintainability point.
Yes, yes.
Then another point is territorial jurisdiction.
Lordship.
In that sense also, maintainability issue may come.
Lordship,
So maintainability issue is a multifarious event.
Lordship,
Multifarious facts are to be considered
Lordship,
from the point of view of pecuniary jurisdiction, from the point of view of territorial jurisdiction,
Lordship,
from the point of view that it is barred by law,
Lordship.
all these things. Secondly, you have not filed any application possibly under Order 7, Rule 11 stating it was barred.
No, it was not there.
It was not barred.
Lordship.
Second thing, whether you have made any specific pleading that this is barred.
Yes, in my written statement, I have stated.
All right. Put it in your argument.
Lordship.
I'm just giving you these points,
Lordship, Lordship,
which your points should cover.
Lordship,
Your argument, notes of argument should cover.
Lordship,
You come with all these things.
Lordship.
Because ownership question, if this court do not have any jurisdiction, suit is not maintainable, then issue number 1 cannot be decided.
That is correct.
Issue number 1 is on the merit.
Lordship,
That is the crux of the suit.
Lordship,
I am the owner.
Lordship,
But if the court cannot say I am the owner,
Lordship.
then the issue cannot be decided. So your notes of argument shall be prepared, keeping that in your mind.
Then, my lord,
At
today,
any cost, maintainability point must be considered. So what we will do, 1 and 9,
yes,
both should be considered together.
Lordship,
Because had this been a case that the lower court has decided, but trial court has decided that maintainability suit is maintainable,
Lordship.
division bench used to upheld that. In that case, thing will be different. Here the lower court said suit is not maintainable,
Yes,
and division bench set aside
Lordship.
the whole judgment.
Yes,
That means this court will hear it de novo.
yes.
So
Yes.
put all these things in your written notes of argument. Why only file? Have you prepared it?
Only one thing, my lord, should give a care, my lord. While at the last occasion, Mr. Roy had given a copy to me, no copy was given to him. This is very unfortunate. That too from Mr. Roy, senior advocate of this court.
You will do it.
He thought I will learn everything from him.
Since my learned friend has taken up protocol, my lord, I'm saying. I have nothing to say in this matter. I have told
outside the
repeatedly
court-
before this court.
Outside the
And
court
he has
said
given a copy.
you take a copy from me, but be that as it
Is
may.
it the
To give a
proper
copy, hand over the
procedure?
copyright.
I had already handed over to you. I need no copy, but the
My lord, the reason, no, may I just, since,
Whatever that might be, you hand over a
no, that's a trivial matter, my lord. Only one thing, my learned friend has not argued this queries of my lord. Now, if he says, as he has said, he has annexed a judgment.
I will hear you also.
So after giving me a copy, otherwise.
Yes, you come with the notes of argument or argue, whatever that might be.
You
You
come,
have to hear from him also.
lordship.
Monday, will you come Monday?
Well, 1 minute.
My lord, let a copy be given to us, otherwise I will not.
That be prepared first.
Notes-টা কে তৈরি
Give
করছে?
some more time, my lord.
No, my lord, this.
Because, my lord, I have to cover everything, territorial jurisdiction, pecuniary.
No,
jurisdiction.
my lord, subject to
Everything
correction.
has to be written there, my lord.
No, my lord, subject to correction by my lord, may I only draw my lord's attention to one fact, my lord.
11,
11 September.
I won't extend time.
My lord, 11 September. 11
Hard in part adjourned to 11 September.
May I only prefer one indulgence, apropos of what has fallen from my lord,
So
just,
Bagu, the learned counsel for the defendant. You are for customs authority
My lord.
to file notes of argument. Leave is granted. Notes of argument shall be filed on or before 11 September with prior service of copy to the other parties, the other councils.
Lordship.
and so, one indulgence, my lord, one indulgence. My lord has from orally observed, my lord, as to the limitation and territorial jurisdiction, subject.
I'm just
oral-
giving hints.
hints. No, that's, but they have not pleaded that it is.
You argue that.
Yes,
I am just giving the point. The maintainability issue can be decided on these courts.
on this, yeah, but here they have not pleaded
If that is not pleaded, then that will not come.
deeply. That's the only thing.
Raise these points. You must also raise these points.
My lord.
Where is the plaint?
Plaint is page 1.
Okay, let me see the written statement.
Written, yes, written statement I will show. They have said, my lord, that Sea Customs Act and Section 80, same points as in Manton suit. In Manton suit, my lord, it has been straightway decided and no appeal has been preferred from that. So the observation of the Manton suit is binding upon this. My lord, if my lord kindly comes to page 19 of the paper book. The last sentence, the suit is not maintainable in view of the provisions of Sea Customs Act. Page. Sea Customs Act, section number 2. Yes, yes.
All right.
Deep privilege.
আরে ওকে কপি দাও ওর তুমি রাগ করলে কি করে ওই তো আসল লোক আর তো নকল
আমার তো কোনো বেশি আসেনি
কিছু নেই
Item 32.
তুমি জানো
I am appealing on behalf of the plaintiff.
32, I am for the defendant, my lord. I was hearing him. Yes. To prepare a notes of argument.
I will, my lord. I will take today and one more day on facts and then the law. And at the end of it, I will give a note. But if your lordship kindly takes the evidence of the plaintiff's witness. The lordship will recall on the last occasion, I had covered the issue so far as the immovable property in Calcutta is concerned, which is 33 and 34 Mondul Street. I had shown your lordship the manner and method of acquisition, the mortgage and all the related documents. The other business which is of some importance in this suit, which is claimed to be a joint business, is that of Deepak Medical Hall, a medical shop, which according to the plaintiff number 1, original plaintiff number 1, was a business that was started by him. But evidence would show that it was actually a business in the name of the original defendant number 2. Evidence would also show that a person who claims to have founded a medical business, medical shop, and run it on his own, has deposed in course of evidence that he has seen the drug license for the first time in court. The importance of his testimony with regard to Deepak Medical Hall is to show the falsity of the entire case that has been sought to be set up. Kindly, my lord, the examination and cross-examination are slightly lengthy. Kindly, my lord, starts with
Another aspect of your argument is that even if it is assumed that this Deepak Medical Hall was run by the plaintiff, obviously it would not come as a joint property.
No, according to me, it is a business exclusively of the defendant number 2. And the plaintiffs or the other defendants, nobody has a right in it.
Where it is stated Deepak Medical's drug license?
Not drug license, your lordship will file in the evidence. But if your lordship wants to look at the pleadings, kindly see.
Did you mention?
Kindly give me a moment, my lord. Paragraph 10 of the plaint is their case.
No, here it is there. Question 93 onwards.
Yes. No, my lord, your lordship will kindly also see questions 48 to 50 and 75 to 86. Before I take your lordship to 90, from 91 onwards. 48 to 50. Apart from Annapurna Vegetables, was any business set up? Yes, there was a shop called Deepak Medical Hall which was opened. This was a medicine shop. Who provided for the funds of the same? From the family estate, as also from income that had been earned from Annapurna Vegetables. Was it a joint family business? Yes. This was also a joint family business. Then your lordship will kindly come to page question 75. Please tell, when was the business of medicine shop Deepak Medical Store started? It was started in the year 1961. Was it a proprietorship or partnership business? That was a proprietorship business. In whose name the said business was started? The proprietor's name was Vivekananda Mondol. Who provided funds for running the said business? Funds came from the joint family estate. At what point of time? At that point of time, what was the age of Vivekananda Mondol? I am unable to compute the exact age of Vivekananda Mondol. Kindly tell whether he was a major or minor. Yes, he attained majority. At the relevant point of time, what was the source of income of Vivekananda Mondol? He used to get money from the joint family estate. Who supervised the affairs of the said business? That business was run by Gurupada Mondol, Oshimananda Mondol, and Sahadev Mondol. Did any person other than Sahadev Mondol look after the said business? Yes, all of us jointly looked after that business. Who used to maintain the day-to-day administration of the business? Sahadev Mondol. Who used to maintain the books of accounts of the business? Entries in the books of accounts relating to that business were made mostly by Sahadev Mondol and Gurupada Mondol. For the said purpose, you used to receive supply of medicine from the suppliers who used to supply medicine. Oshimananda Mondol used to receive supply from the wholesalers, and Gurupada Mondol and Oshimananda Mondol used to receive the supplies. I am referring to PD8. Kindly go through these documents and tell what are these documents about. These are the bills showing the purchase of medicine. Signature of Oshimananda Mondol appears on this. Could you identify the signature of Oshimananda Mondol? Kindly tell who has issued this document and where from these bills have come. These bills were issued by the supplying medical companies. Who are the companies? Raj and Raj Medical Stores, BC Enterprises, Giriraj, Govardhan, and Ghosh Medical Agency were the suppliers. On the last occasion, you have deposed before this court that Vivekananda Mondol was the proprietor of Deepak Medical Stores. Is it correct? Yes. You had also deposed that Deepak Medical Stores was started in the year 1961. Do you recollect? That is so. Can you tell that in the year 1961, when Deepak Medical Stores business was started, did Vivekananda Mondol have any independent income to start such business? He took money from the joint family fund in order to commence the business. On the last occasion, several documents which were PD number 8 were shown to you. You had deposed that these documents were related to supply of medicines to Deepak Medical Hall. Do you remember that? These are the purchase bills being the purchases made by Deepak Medical Stores from other agency. Shown documents being cash memos. On the last occasion, you had deposed that Oshimananda Mondol's signature is appearing in this document. Do you recall that? Yes. Oshimananda Mondol's signature is appearing on this document. Apart from these documents, can you tell whether there were any other companies which supplied medicine to Deepak Medical Stores? This is Jabda Khata, in which other suppliers' name would be recorded. In respect of other suppliers, whether these kind of documents were given by the parties to Deepak Medical Stores, it may be there are other memos. How do you receive these documents from the respective suppliers? In the usual course of business. Kindly now come to my question 252. shown PD 35 at pages 165 and 166. What do you know about this document? This is the purchase account book of Deepak Medical Hall of the joint family. Whose handwriting appears on the 2 pages? My handwriting appears on the 2 pages. On the next page, whose handwriting appears? My handwriting appears at the top, and below it, the handwriting of Sahodeb Mondal appears. Do you know the handwriting of Sahodeb Mondal? Yes. Would you kindly identify the handwriting of Sahodeb Mondal at page 166 of the judge's brief of documents? Yes. Do you know his handwriting? Yes. Then encircled. I am referring to another page, copy whereof it is at page 168 of the judge's brief of documents, being part of PD 35. Please tell my lord as to what the handwriting relates to. It relates to the purchase of medicines. Could you tell my lord who has written on this page? The upper portion of this page is written by me, and the lower portion of the page is in the writing of Sahodeb Mondal. Do you know the handwriting of Sahodeb Mondal? Yes, tendered the document and marked as T2. Please turn to the next flat copy page, copy whereof is at page 167 of the judge's brief of documents. Please tell my lord as to what this page is about. This is with regard to purchase of medicine. Please tell my lord whose handwriting appears on this page. The upper portion of the page was written by me, and the lower portion of the page bears the handwriting of Sahodeb Mondal. Do you know the handwriting of Sahodeb Mondal? Yes. Please look at the next flat page, copy of which is at page 169 of the judge's brief of documents, which is also part of PD 35. What is this document about? This is also with regard to purchase of medicines. Whose handwriting appears on this page? The upper and middle portion appears in my handwriting, and the lower portion is in the handwriting of Sahodeb Mondal. Do you know the handwriting of Sahodeb Mondal? Yes. I am referring to another page, copy of which is at page 170. Please tell my lord what this document relates to. This page relates to purchase of medicine. Whose handwriting? Upper portion is in my handwriting, and lower portion is in the handwriting of Sahodeb. Do you know the handwriting of Sahodeb? Yes. Now, my lord, after 270, your lordship will kindly take questions 309 onwards. Mr. Mondal, I am now referring to a document that is PD3 at page 4 of the vernacular brief of document, and translated portion thereof at page 4 of the judge's brief of document. What are these documents about? This is a letter. Whom this letter is addressed to? Addressee is myself. One name, Roton, has been referred to in this letter. As to who is this Roton is? Roton is an employee of our Deepak Medical Hall. Whose handwriting is appearing at this document? This is my elder brother Sahodeb Mondal's handwriting. Whose signature appears on this document? The signature is of Sahodeb Mondal, my elder brother. Why this document was written? This letter has been written to me informing that Roton has been paid salary for the Bengali month Oshin, and I used to sit then in Deepak Medical Hall. Do you know the handwriting and signature of Sahodeb Mondal? Yes, I do. Thereafter, Miller kindly takes the cross-examination on this issue, which starts at question 431. Did you ever know any person by the name of Akshay Kumar Pal? No. Up to question 315, Malad, was questions in chief. Now Malad comes across. Did you ever know any person by the name of Akshay Kumar Pal? No. Did you ever know any person by the name of Jashodanandan Mullik? Yes. Who was he? He was the salesman of the medicine shop. Which medicine shop are you referring to? Deepak Medical Hall. Would you be in a position to contradict that Jashodanandan Mullik was a compounder in that medicine shop? He was the salesman of that said shop. Would you be in a position to contradict me if I say that Akshay Kumar Pal was also one of the compounders in that shop? I do not know. Kindly look into the document which has been marked as Exhibit T2 in this proceeding. According to you, whose handwriting would appear in this page? This is the handwriting of one Sahodeb. Which entries are you referring to? The first entry is in my handwriting, and the rest of the entries are in the handwriting of Sahodeb. Would you be in a position to contradict me if I say that the fourth entry at the right-hand side, which reads drug chamber, till 10th entry being Ghosh Medical, those were in the hand of writing of the compounder of the medicine shop? I do not agree, because these are not in the handwriting of the compounder. Is it your evidence that the second and third entries of the right-hand side of the page, being Sandoz India and Bengal Medical, those were in the handwriting of Sahodeb? This is my handwriting, Gurupada Mondal. The rest of the entries are in the handwriting of Sahodeb. I am showing you that handwriting of Sahodeb starts from the entries medicine purchased, which is immediate immediately after the entry of Ghosh Medical. I do not agree because Shohodev's handwriting starts from drug chamber. Kindly look into this document which has been marked as Exhibit T4 in this proceeding and tell my lord whose handwriting would appear from this document. The entry appearing at the top reading Chatterjee is in my handwriting. BMS Medical is in my handwriting. Bhattacharjee below Do and Do brothers are in my handwriting. From Dhor Medical Agency to second Do below Prabhu Bhai are in the handwriting of Shohodev. The entry reading as international is in my handwriting. The rest of the entries are in the handwriting of Shohodev. That is to say, from Anand Medicine Company to the end of that page. I am suggesting to you that the entries regarding Dhor Medical Agency to the second Do under Prabhu Bhai were made by the compounder of the medicine shop. I do not agree. These are in the handwriting of Shohodev. I am further suggesting to you that the entries drug chamber to Ghosh Medical in Exhibit T2 were in the handwriting of the compounder of the medicine shop. Apart from the first three entries, the entries starting from drug chamber to general charges appearing at the end of that page are in the handwriting of Shohodev. When was the premises number? Kindly up to 444 was on this topic. Then the cross-examination proceeds again from 553. On an earlier occasion, you deposed about a business carried on under the name and style of Deepak Medical Hall. Do you recall that? There was a medical shop in the name of Deepak Medical Hall and it is still there, but it is closed. This business belongs to whom? Though the license is in the name of Vivekananda Mondal, but it belongs to every one of the joint family. When did the business commence? During 1961. From the very beginning, the business was carried on under the name and style of Deepak Medical Hall. Yes. Do you know who Deepak was? He is the eldest son of Vivekananda Mondal. Is he still alive? No. He died in an accident. Can you contradict me if I say that Deepak died in 1962? It is not possible to remember the facts, all the matter of such long ago. Can you contradict me? Just a minute. His case is it started in
Stated earlier about starting of business of Deepak Medical.
1961 is what he says.
Here.
In the evidence. Here he says, here I'm not coming to that. Our cases, it was started after 1962. He says it was started in 1961. Kindly take question 560. Can you contradict me if I say that only after the death of Deepak, this business was commenced by Vivekananda Mondal, and that is why the name of the business on the basis of his deceased son? No, I will not. But the business started during 1961. I do not remember when he died. According to you, this business of Deepak Medical Hall was the business of the alleged joint family. Yes, every one of the joint family is owner. You claim that you were also one of the owners of that business. Yes. Can you tell my lord, for carrying on the business of a medicine shop, what licenses are required to be obtained? Trade license and medical license. That is all. You are certain. We had these two licenses. So a person who has run a medicine shop does not even know that there is a drug license required. Without a drug license, no medical establishment or a medicine shop can be operated. Now, after 564, kindly take 565. Do you know that for carrying on business in medicine, one has to obtain drug license? Yes. In respect of the business carried on under the name and style of Deepak Medical Hall, was such drug license obtained? At the time, drug license, trade license, and poison license were there. I am not aware what is the state of affair at present. On the last occasion, when you deposed, you talked about the trade license and medical license. When did you remember about the drug license and poison license? I have been always telling that at material point of time, trade license, drug license, and poison license, these three were needed. I am not sure about the requirement of the present time. This is a material alteration in his answer because he has got tutored in the break between the 2 days. Look at the answer given by you in answer to question 563 and tell whether you want to contradict the answer given by you on that occasion. I will also say that poison license is also required. Who was the registered pharmacist at the time in Deepak Medical Hall? There was a boy named Joshoda. So, your lordship will recall, I've just read, Joshoda Nandan Mullik, he says, was the salesman. Now he says he was a pharmacist. Tell us whether any business in medicine can be carried out without first obtaining drug license. No, it is not possible to do so. Do you remember when the drug license in respect of Deepak Medical Hall was first obtained? I do not remember, as the incident relates to long time back. Shown a document dated 5th June 1965. What is this document about? This is a drug license. When was this drug license issued? License was issued on 5th June 1965, which was valid till 31st December 66. Look at the license once again. Who is the qualified person in charge of the medicine business? Vivekananda Mondal. From this drug license, would the name of the registered pharmacist appear? The name of Sri A.K. Pal appears in this license. This A.K. Pal is that Akshay Kumar Pal. When the business was started by Vivekananda Mondal as proprietor of Deepak Medical Hall, and the registered pharmacist was Mr. A.K. Pal. That is so. Though I do not remember exactly, but the name of A.K. Pal is written on the drug license. Shown a document also dated 5th June 1965, which is also a part of defendant's document number 3 in this proceeding. What is this document? This is a drug license in respect of medicine. In whose favor was the license issued? This was issued in the name of Vivekananda Mondal and A.K. Pal. Witness volunteers, this license was issued in the name of the compounder A.P. Pal. Have you seen this document before? I am seeing this document for the first time today. I did not see it before. So a person who says he started a business, went and sat in the business, ran the business, is saying that he saw the drug license for the first time in course of evidence in the year 2000. I think this evidence that is being recorded is in 2004, 40 years later. You have deposed that you used to carry on business of Deepak Medical Hall. What are the differences between those two exhibits? In exhibit 17, there is an item category of drugs which spells out other than it is specified in schedule C and C1. This does not appear in exhibit 18. Can you tell why 2 drug licenses were issued on the same date in favor of Deepak Medical Hall proprietor Sri Vivekananda Mondal? I cannot say, as I do not remember. You cannot say you had nothing to do with the business. I do not agree. This was a joint business and I was one of the owners. Now, kindly thereafter, this is 582, kindly thereafter come to question 627. Where was Deepak Medical Hall situated? At number 36 Kali Krishna Tagore Street. The property being number 36 Kali Krishna Tagore Street belonged to whom? It belonged to the joint estate of ours. I suggest that the business of Deepak Medical Hall was carried on by Vivekananda Mondal from the tenanted premises. The business of Deepak Medical Hall belonged to the joint estate, but Vivekananda Mondal used to run the business as proprietor. I suggest that Vivekananda Mondal used to carry on the business from a tenanted premises. Yes. The answer which you gave to the first question put by me to you today is incorrect. Whatever I told was correct. Who was the owner of the premises from where business of Deepak Medical Hall was carried on by Vivekananda Mondal? Some Mr. Shingho was the owner of the premises. You do not know the name. I cannot remember the name of the owner, but the premises was named as Shingho God. Would you contradict me if I say that the DT Sri Lokhinarayan Thakur Ju and others were the owners of that property? I do not contradict. Do you recall who on behalf of Sri Lokhinarayan Thakur Ju and others used to collect rent in respect of the premises in question? Whatever I have to say in reply to this question, I have told earlier in my evidence. Mr. Mondal, please answer the question. One, Mr. Shankar Babu, he was the owner of the premises. Can you tell, my lord, the relationship between Shankar Babu, who you mentioned, and the DTs? It was a Devottor estate. And what was the connection of Shankar Babu with the Devottor estate? Shankar Babu was the owner of the premises. In the shop room from where the business of Deepak Medical Hall was carried on, was there any electricity there? Yes, there was electric connection and also there was telephone connection. Who obtained such electric connection in that premises? It is a matter of long way back. I cannot recall exactly. Did you obtain such connection? I did not myself obtain the electric connection. I do not recall the person who obtained that connection. It is a matter of long back. That is why I cannot recall. The witness volunteers. My elder brother Shahadev Mondal used to do all these things. He might have obtained the connection. But you did not obtain such connection. No, I did not obtain the connection. My elder brother obtained the connection. Mrityunjoy also did not obtain such connection. Shahadev, who was the head of the family, used to do whatever had been done. Do you recall when such electricity connection was obtained at that premises? No, I cannot recall. Was it prior to 1962 or was it after 1962? Can you remember? The shop room came into existence in the year 1961. Would you contradict me if I say that the electricity connection in that shop room was obtained by Vivekananda Mondal in September 1962? I cannot recall. It goes back too long way back. The shop room was established in 1961. To refresh your memory, I am showing you a document dated 11 September 62 issued by CESC Limited in favor of Vivekananda Mondal. Kindly look at this document and tell my lord whether you know anything about this document. Maybe it was issued in his name, but I cannot recall. Did you ever have any occasion to see this document before? It was lying with Shohodev. How can I come across this document? He did not show me any document. All the papers were lying with him because he was the head of the family. Now they are showing the documents one by one. Mr. Mondal, I am suggesting to you that this was a receipt for security deposit issued by CESC in favor of Vivekananda Mondal for supplying electricity at 50 Kalikrishna Tagore Street. I cannot recall this matter because I am now 84 years old.
Is there any explanation how joint fund came to be invested
No,
in
no,
Deepak
no,
Medical?
no, no. Apart from the statement, whatever has been asked, there are two common threads. In chief, everything has been started from the joint family business. And in cross, everything was with Shohodev. Shohodev had everything. He was the head of the family. He only knows what happened. He doesn't know anything. He doesn't know anything, but he is only here to make an allegation that everything was started by the joint family fund. There is no evidence of a nucleus, there is no evidence of a corpus, there is no evidence of a joint family. And as I have shown your lordship will recall, Shohodev coming to Calcutta in 1924 has been admitted. So, and Bhushan, the father of the original defendant number 1 and the 2 plaintiffs, was alive. So in the lifetime of the father, the brothers were not living together. So therefore, even on the death of the father, there was no joint family because admittedly, Shohodev was living with his family in Kolkata. So if there was no commonness of mess and commonness of living in 1926, when Bhushan died, there cannot be a joint family.
You put everything in your notes of
Yes. In a Daibhag joint family, my lord, the Daibhag joint family among the brothers could only start on the death of the father. And if there was a joint family which started on the death of the father, then the other brother Basudev, who is not even a party to this suit, would also have been a part of the joint family. Fact that there was no joint family is evident from the fact that Basudev is never made a party to the suit.
Was it asked in cross-examination?
Yes, yes. I had read out that portion to your lordship. He was explicitly confronted about the existence of Basudev when he said he separated in the lifetime of the father. Where is the question of separating in the lifetime of the father in a Daibhag family? Who obtained telephone connection in the shop room wherefrom the business of Deepak Medical Hall was carrying on? I have already stated that I cannot say anything on this matter because my elder brother used to do everything in this regard. Did you or Mrityunjoy obtain such telephone connection? We did not do anything about this. Did you ever pay any income tax personally? No, I never paid income tax personally. How are you connected with Annapurna Vegetables? I am stopping here for the moment. Deepak Medical Hall, Malad, I am not taking your lordship to the end of the cross-examination where the general side, the suggestions are given. There is a question where, Malad, he has been asked about the dose in which Pentid has been used to be administered. He comes out with 2 doses which are incorrect. But I'll put that in my note. I'm just drawing. A person in 1960s and 70s sitting in a medical shop would know the dosage of Pentid by heart. It is a first generation antibiotic of its own. The question was specifically put to him to impeach his credibility and call his bluff to the extent that he was in any way involved in the medicine business. Now, my lord, similar situation will be there in respect of the other businesses. So far as 2 businesses by the name of Annapurna Vegetable Stores and Mondal and Company are concerned, I have shown your lordship my case that Annapurna was a sole proprietorship business of the plaintiff number 1.
This was also sole proprietorship, Deepak Medical.
Deepak is of the defendant number 2. All the businesses that are tried to be impleaded in the suit either belong to any of the plaintiffs individually or to, except Mondal and Company, which we have shown, we have pleaded and shown, and I will come to that on the next day. MAJUMDAR and Company was a business that was started by Mrityunjoy, the second plaintiff, as a partnership with a stranger to the family by the name of Barindranath Chakraborty. That partnership was dissolved, and thereafter Mrityunjoy continued with it for a very small time as a sole proprietor, and thereafter Mrityunjoy makes a gift of it to Parmanandu, the defendant number 4, and the younger son of Sahadev. That deed of gift, it's a gift of movables, so it's not a registered gift, it's by way of an affidavit, has been tendered in evidence and has been marked as an exhibit. So the gamut of the evidence would be that the case of joint family fund, investment from the joint family fund into businesses running in the individual names of the alleged members of the joint family. There is no evidence, there is no document. There are some scraps of paper where accounts are maintained, which are put up to show, oh, see, Sahadev was maintaining the accounts. But that, with respect, cannot be the basis of establishing the existence of a joint family. There is also no case of blending made out. It is not as if that their case is that even though a business was in the name of the individual and was started by the individual brought the proceeds into the joint family hotspot. So no case of blending is made out in the plaint. Once there is no case of blending made out in the plaint, there is no presumption in law that a business standing in the name of a person, even if he is a member of the joint family, is a business of the joint family. I kindly mark this. There are two things. One, I say there is no joint family at all. Secondly, even if I assume without admitting that there was a joint family, there is no presumption available in law, and that is clarified by the Supreme Court. And I'll show that there is absolutely no presumption of the fact that merely because a person is a manager of a joint family, or merely because a person is a member of a joint family, a business started by him in his individual name is a part of the joint family. Unless it is treated, unless there is a blending. But what is the evidence? There is no evidence. The evidence cannot be that I used to sit in a shop room. So today, my nephew starts a business. I go and sit there to assist him does not make me a stakeholder in the business.
Especially when it is in the individual name.
Yes.
That is your point.
Yes. Well, may I stop here for today? One more day on facts and then the law.
Finish it. Next day, finish it.
I will try, my lord, but there are at least 5 or 6 judgments to be shown. My lord, kindly keep it on the 5th, my lord. Tuesday.
Heard the learned counsel for the defendant in part to 5th September.
My lord, before your lordship takes on the next matter, my lord, mine is item number 34. My lord, witness action. My lord, it is appearing, my lord, I think today as under the heading witness action, my lord, I have concluded, my lord, it has to be listed for arguments. So subject to any day, my lord, possibly your lordship will list.
That matter was fixed. The other matter.
My lord, on the last occasion, I think your lordship fixed it on the end of September sometime. Your lordship, whenever it is fixed, your lordship will keep both the matters together, my lord, because
Definitely, give me the date. একবার চেক করে নি বলো এটাকে লেখো the matter will appear in the since evidence is complete, witness action is complete, the suit will appear under the heading argument on the date টা দেখে দিয়ে দেবে
my lord, whenever it is convenient, your lordship will give the
same date.
Yes.
Check it.
Very good. I'm grateful, my lord.
Item 33. Well, I'm for the defend number 1.
Evidence is closed.
My lord, I appear for the defend numbers 3A to 3F.
Defendant adduced evidence last.
Yes.
So defendant will start.
My lord, I have not adduced any evidence.
I chose not to adduce any evidence. I will also show, my lord, that the plaintiff has been unable to prove its case. The burden was on the plaintiff to
Who is the
prove its
last
case.
person examined?
My lord, it was defendant number 3's witness, my lord.
All right.
Defendant number 3A to F.
So defendants will come start
So
the
I
hearing.
can start, my lord. I'm the defendant number 1. My lord will kindly take the plaint.
You first give an outline of the suit.
Yes, my lord. My lord, the plaintiff claims to be the grandson of one Subol Chandra Saha, who had a lot of property, including a property at premises number 13 Mandal Street. Plaintiff claims that the Subol Chandra Saha made a will by which he gave only life interest of premises number 13 Mandal Street to the grandmother and thereafter to the father of the plaintiffs. Now the plaintiff has claimed that by undue influence, that is, I am the defendant number 1, I was earlier the defendant number 2. When the suit was filed, the grandmother was made the defendant number 1. Grandmother has since passed away. So I have become the defendant number 1 right now. So the plaintiff claims that I, the defendant, I am the other son. The Subol Chandra Saha had 2 sons. One was Ashok Saha, the other is Amol Saha. I am Amol Saha. I am the defendant number 1 right now. Ashok Saha has 2 sons. The other brother, my brother.
Chandra Saha, the plain case is Subol Chandra Saha by testamentary bequest given the proper life estate to.
My lord, if your lordship takes the plaint one paragraph, I think the genealogical table will help. Just to understand, my lord, only for that purpose. I will then, my lord, explain what is the matter. My lord, paragraph 1, that is all, my lord, if you see. Take. Paragraph 1 of the plaint. A genealogical table has been set out. In para 1, my lord. Subol Chandra Saha, he is the grandfather. He had a wife, that is Shonamoni Saha, who was made the defendant number 1 in the suit. Then Ashok Saha, who's the defendant number 3. And Amol Saha, who's the defendant number 2. When the suit was filed, this is how it was filed, my lord. As the Shonamoni Saha, defendant number 1, Ashok Saha, defendant number 3, and Amol Saha, defendant number 2. Anindo Saha and Amyo Gopal Saha, the plaintiff number 1 and 2, are sons of Ashok Saha. Suit proceeded on the basis that Subol Chandra Saha made a will by which life interest of premises number 13 Mandal Street was given to Ashok Saha, was given to Shonamoni Saha, the wife.
Life estate.
Life estate. Right to life. Right to life. Sorry. Lifetime interest was given to Shonamoni Saha, life estate. And subsequent thereto, Ashok Saha and his sons. Plaintiff has made out a case that Amol Saha, I am the defendant number 2. When the suit was filed, I had undue influence over my mother, that is Shonamoni Saha, and I caused my mother to sell this property, 13 Mandal Street, in favor of one Ashoka Biswas, who is the defendant number 4, now the defendant number 3. This is the case made out. Over and above that, the plaintiff has made out a case that there were certain items, given a schedule of certain goods, which apparently belonged to Subol Chandra Saha, the grandfather, and I, Amol Shah, being the executor to the will of my father, I have sold those goods and I have misappropriated that money. So claim a money decree against me on account of sale of certain goods which apparently belong to my father, which I have not given to my nephews, that is Anindo Shah and Amol Gopal Shah. This is the case made out. That is all, my lord. So, my lord, so far as the case against me is concerned, the plaintiff had to prove 2 things.
You are?
I am, my lord, right now the defendant number 1, because your lordship will find
Amol Shah.
Amol Shah. Shonamoni Shah, the mother, has passed away.
The allegation against you is that
undue influence over my mother, number 1, and number 2, that I have sold certain goods. My lord, your lordship will find in paragraph 4. 4A, para 4A, at page 3. The defendant number 2 wrongfully and illegally sold various articles, particulars, and value thereof would appear from a schedule being annexed to D. The plaintiff claims an enquiry and a decree out of the said sums in terms of the said will. So these are the only two claims against me. My lord, if your lordship now comes, my lord, to the prayers of the plaintiff, I just want to show, my lord, what is the claim against me. That is all, my lord. Plaintiff claims serial number 1A is decree for delivery of cancellation of the purported deed of sale dated 15th December 1995. This is the deed of conveyance which the plaintiff claims that the grandmother has executed in favor of Ashoka Saha. I have no role to play in this apart from the allegation that I had undue influence over my mother and I had influenced my mother to execute the deed of sale. That is all, my lord. Prayer B, decree for perpetual injunction restraining defendant number 1, 2, and 4, each one of them from dealing and or disposing of or alienating and encumbering the said property. This is the 13 HON'BLE Street property. C is what I am interested. C and D, my lord. Not C also. C is also inquiring into damages and a decree for such sum as may be found due and payable. That is A in lieu of A and B. Prayer D is the only prayer concerning me. Decree for the said amount as mentioned in para 4A, that 48,000 rupees.
So allegation against you is that the original defendant number 2 wrongful. Original defendant number 2.
That is me, my lord. Original defendant number 2 is me.
Ashok Saha.
There is a problem. I believe Mr. Mukherjee will also address you. The amendments have been carried out, but the body of the plain motion.
Yes, my lord.
Amendment.
Yes, my lord.
Original defendant number 2 has repealed original defendant number 2.
Yes, my lord.
The amendments, after the subsequent parties are coming, the body of the plain do not reflect.
The plaintiff has not changed the
So
body.
head is one, body is other.
Yes, my lord. Absolutely. Well, there is that. Well, for a plain, the head, the body, and the tail, everything has to be there. Then the plaintiff is found. Justice Sanjeev Banerjee has given in a judgment. The full body makes it an animal. Head, body, and tail, legs and tail, everything put together. So, my lord, here there's some confusion as regards who is. I am the original defendant number 2, who is right now the defendant number 1, because defendant number 1 has passed away, and all the legal heirs are on record. My lord is looking at the plaint that allegation of undue influence, your lordship will find in paragraph 11 against me. Paragraph 11, the relationship between the defendant number 3 and the plaintiffs on one hand, and the defendant number 2. Defendant number 3 is the father of the plaintiffs, and defendant number 2, that is me, and the uncle. Defendant number 2, on the other hand, is very strained. The plaintiff verily believe and state that the purported deed of sale of premises number 13 MAJUMDAR Street has been caused to be effected as a result of wrongful and malicious act of the defendant number 2. This is allegation against me, number 1. Only out of spite and to entangle the plaintiffs, the defendant number 2 into litigation. The defendant number 2 has exercised undue influence and coercion upon the defendant number 1, persuaded the defendant number 1 to put her signature upon the deed of sale being annexure so and so. And this is the deed of sale of which they are asking for cancellation. So, my lord, if I may submit, my lord, so far as defendant number 1 now and defendant number 2 earlier, that is me, is concerned, only 2 allegations. One, that I had undue influence over my mother, because of which I made her sign the deed of conveyance. That is one allegation. Number 2, paragraph 4A, I have sold certain goods which apparently belong to my father, and that 48,000 is required to be deposited in court. These are the 2 allegations they have made. Your lordship will find, my lord, that schedule 4A, that is annexure D, is, my lord, at page, I actually don't have a paginated, I think page 21 of the plaint. This is the annexure which they have given. I don't think this is also the annexure, my lord. Schedule D is not there.
Schedule D?
It should be annexure.
Indenture made on 18th or 15th?
My lord, this is annexure Well, in paragraph 4A, although it is referred to as annexure C,
it may be C, it may be D. Both are written.
Both are written. I do not
do
know
like
what it is. C. Well, if it is C, then it is at page
Whatever
21.
that might be, it's a
21.
nature, 25th day of December,
Yes, ma'am.
1995.
No, my lord. Annexure C is something else. At page 21, there's a Bardwan property, ambassador car, gold ornaments.
No, it's following that.
Yes, my lord. Following that is, my lord, annexure D. This is the deed of conveyance of which they're asking cancellation of. This, my lord, so far as I am concerned, only allegation is that I had undue influence over my mother to put the signature and nothing more.
And the property was sold out to one
Ashoka Biswas, whose legal heirs are now defend number 3 onwards. Defend number 3A, B, C, D, E, F. That is Mr. Ghosh's client. He is the real defendant in this suit. He is the real defendant.
Definitely, he will be affected.
He is the one who's going to be affected. So, my lord, so far as the defend number 1 is concerned, that is me, my client, the plaintiff had to prove 2 things. One, that I had undue influence over my mother and I made my mother sign that document. That is number 1. Number 2, that the items at page 21, schedule C, they belong to my father and I have sold them illegally. These are the 2 things he had to prove. The burden was on him. Your lordship takes, your lordship is aware, section 100 and 101 of the Evidence Act, my lord.
Burden of proof.
Burden of proof here. I'll just read it out, my lord. Burden of proof 101. Whoever desires any court to give a judgment as to any legal right or liability dependent on existence of facts which he asserts must prove that those facts
Definitely,
exist.
he must have to
So
prove.
he must have to prove. My lord will now take the deposition to see what he has proved. There are, the plaintiff has given evidence.
Mr. Ghosh, how long would you take?
I will take 5 more minutes, my lord.
I will take some time.
I will take 5 more minutes.
Because I am giving my title on the basis of this deed. I will have to, my lord, uphold it.
I will take only 5 minutes and not more, my lord. Your lordship will take the evidence of the plaintiff.
You did not turn out in the morning.
I was
He
outside.
was busy eating lunch, my lord. Preparing to eat lunch.
Before that.
What a heavy lunch he ate, I saw, my lord.
11, I was outside, but I'll move it.
Yes.
My lord, around 264 questions are there. Lordship will find, my lord, the questions which relate to me are, my lord, 29 to 30.
In chief.
In chief. Para 29. Question was asked in chief. Did Shonamoni Shaha, that's the grandmother, reside at 13 Mondol Street, Kolkata until her death? After the expiry of my grandfather, my grandmother Shonamoni Shaha used to live with us in 13 Mondol Street, Kolkata. 6. But in the first week of December 1995, my uncle forcibly took her away to premises.
Possibly.
My lord, sorry, possibly, but later on, my lord, in questions 60 and 62, it has been changed to forcibly. In the examination chief only, he has clarified. It should be forcibly. Forcibly took her away to premises number 22, Mondol Street, Kolkata 6, and since then, she has been residing in the said premises. What happened after the first week of December 1995? My uncle possibly, now again it should be forcibly took my grandmother away to premises number 22 Mondol Street, Calcutta 6, and in the third week of December, defend number 3, Ashoka Biswas, came to us and told us that we had to vacate the house because the said house was purchased by them. Now, my lord will jump to question 37. Did Ashoka Biswas come alone or with somebody else? No, she did not come alone. She was accompanied by my uncle and another 5-7 persons. Can you name him? Amal Saha. Is your uncle present in court today? Yes. Can you name him? Amal Saha. Then, my lord will kindly take 44. Oh, my lord, well, go on, my lord. On the last occasion, you deposed that Ashoka Biswas asked you and your family members to vacate premises number 13, Mondol Street, Kolkata 6. Can you recollect that? Yes, I can recollect. Can you tell whether your uncle Amal Saha was present when Ashoka Biswas asked you and your family to vacate premises number 13 Mandal Street, Kolkata 6? Yes, he was also present there. Did Amal Saha support Ashoka Biswas or oppose her? Amal Saha, my uncle, supported Ashoka Biswas at that time. What happened thereafter? My uncle and Ashoka Biswas both forcibly wanted us to vacate the said premises by showing a forged deed, and we opposed the same. Well, next we'll come to question 53. Have you received any money in this respect from your uncle Amal Shah, who is present in court today? No. Did your brother, the co-plaintiff, or your father receive any money from Amal Saha, who is present in court today? No. According to the will of your grandfather, Amal Saha was the executor of the last will and testament of your grandfather. Is that correct? Yes, that is correct. Now, my lord, next. Did Amal Saha pay you or your brother, the co-plaintiff, or your father any money in terms of the last will and testament of your grandfather? No. My lord, next we'll kindly come to question 60. Same page, my lord. On the last occasion, you have deposed that your uncle forcibly, here it is, they use the term forcibly, taken her out from 13 Mondal Street in the first week of December 1995. Can you recollect that? Yes. By the word uncle, what do you mean? Yes, I have referred to Amal Saha. Shown questions 29, 30. Kindly read the same.
Forcibly.
Forcibly. That's all. Then, my lord, will kindly come to question 90. Question 90. Still examination in chief going on. Can you tell my lord why you have instituted this suit? My uncle, being defendant number 1 in this case, suddenly came up and said that the house has been sold. That is why we have instituted the case. 92, my lord. Again, according to your uncle, being the defendant number 1 in the case, who has purchased the property situated at 13 Mandal Street? The house was sold in favor of defendant number 3, Ashoka Biswas. Then, my lord, question 105. Well, it's still in examination in chief. Was your uncle, who is now defendant number 1, was in occupation of 13 Mandal Street, Kolkata, 1995? No, my lord, he was not in occupation of that building. Well, question 126. Now, my lord, will kindly take. Well, it's still in examination in chief. 126. 126. Can you tell where Amal Saha is residing in the year March 1995? At 22 Mandal Street, Kolkata. Since when Amal Saha is residing in 22 Mandal Street? He is residing there from 1st December 1995. Prior to that, where was Amal Saha residing? Prior to that, he used to reside at 13 Mandal Street. Question 129. In 13 Mandal Street, how many rooms were in occupation of Amal Saha prior to 1995? He used to use only one room of first floor of the premises. How many rooms Amal Saha was occupying prior to 1st December 1995 at 13 Mandal Street? Prior to 1st December 1995, he used to reside in one room. On and from 1st December 1995, was there any room in occupation of or possession of Amal Saha at 13 Mandal Street? No, he did not have any occupation as such. He had no rooms in that premises and he was not residing there. Malal will now take question 157. Well, this is when cross-examination has commenced. I am showing you a document, DD9, appearing at pages 60 to 67 of the judge's brief document.
Rajat in examination in chief continued.
My lord, oh, sorry, my lord, my mistake, my lord. Sorry, my lord. I thought, in fact, Mr. Ray takes over. My mistake, my lord. I am showing you a document marked as Annexure DD9, appearing at pages 67 to 70 of the judge's brief of documents. What is this document? My uncle Amal Shah filed a case against myself, my brother, my mother, and my aunt under section 144. This is that document. My lord, I missed out one question, my lord. We'll kindly take question 81. These are the only questions, according to me, which has any relevance so far as I'm concerned. Question 81 to 84. 81 to 84, my lord. Shown a copy of a typewritten document being marked PD4. Malad, this is that annexure C in the plain, same document. Who has prepared this document? While filing the suit, we got this schedule prepared. Question 82. Is there any basis of such preparation? Yes. This is the schedule of movable and immovable of assets and other assets that we have. What about the valuation? 4,29,000. Who is in possession and custody of the ambassador car now? It is not in our possession and we are never told as to where and in whose custody it is lying. This is all the evidence that is given in support of Schedule C. Who owns, in whose name it is, what has happened to it, who it has been sold to, nothing given. Any documents pertaining to that, nothing given. The burden was on the plaintiff to prove that these goods, these items that in Schedule C, they belong to my grandfather, because that is the case made out. And then I have sold those goods and have misappropriated that money.
No, the allegation basically the plain case is that Sonamoni Shaha was undue influence was exercised upon Sonamoni
So
Shaha.
that is so far as only the deed of conveyance. There are two separate things. There is a deed of conveyance which was executed by Sonamoni Shaha in favor of Ashoka Biswas. The legal heirs are the clients of Mr. Ghosh. It is alleged that I had undue influence over my mother and I made my mother sign that document. That is one allegation. Second, altogether separate is paragraph 4A, where they say that the defendant number 2 wrongfully, illegally sold various articles, particulars and value whereof would appear from Schedule Annexure C. The plaintiff claims an inquiry and a decree out of the said sums. So second allegation that I have wrongfully sold certain goods and I have misappropriated that money. So what has to be shown? Number 1, those goods belong to someone over whom the plaintiffs have some right, possibly the grandfather here in this case, because it's the grandfather's estate they are talking about. So plaintiff, defendant number 1, that is me, I have sold certain goods which belong to my grandfather and I have misappropriated the money, which is 4.29 lakhs. That's what they are saying in the plaint, in para 4A. So they had to prove that those goods belong to my grandfather, number 1. Number 2, I have sold them and I have the money. Both these things had to be proved by them. In support of that, what do they prove? Question 81 to 84. That is all they prove. Shown a copy of the typewritten document PD4. Who has prepared this document? He's saying, I have prepared that document. That is all. While filing the suit, we got this schedule prepared. By we, I mean I suppose they mean the two plaintiffs. Next. Is there any basis of such preparation? Yes. This is the schedule of movable and immovable and other assets that we have. He's not proved that we have. 83. What about the valuation? 4,29,000. Who is in possession and custody of that ambassador car now? It is not in our possession. We were never told as to where and in whose custody it is lying. He had to prove that these belong to the family or the grandfather and they have some right over it, or I have sold it. None of these are proved by him. The burden was on him to prove it. I showed section 101. Now, my lord, the other questions I'm showing is for the purpose of that undue influence. Has he made out a case of undue influence? So from the tenor, well, I'll go through the entire evidence, then I'll make my submissions, because there are very limited questions. Well, I had shown till question 157. My lord, in cross, where again my name is mentioned. 150, I'm showing you a document PD9. My uncle Amal Saha filed a case against myself, my brother, my mother, and my aunt under section 144. This is that document. So nothing else apart from a case file. Well, then, my lord, your lordship will take, well, question 174 onwards is also question 184 onwards is the cross-examination. 184 onwards. My lord, first cross-examination is by Mr. Ghosh. And then, my lord, my cross-examination, my lord, starts. Well, there's two important questions. The judge asked certain questions, my lord. We'll kindly take question 211. 211. These are questions from the court. Is there any relation between Ashoka Biswas and Amal Saha? To that answer, no, there is no such relation between them. So between the buyer and me, there is no relationship. He is accepting. Question 211. Well, next we kindly take question 224. Again, a question by the court. were you present when Ashoka Biswas and Amal Saha came and showed the deed that you were now referring to? Yes, I was present. My name comes only in these questions, my lord. 200. And my lord, my cross-examination is question 242 onwards. Do you know the address 27C Nimo Goswami Lane? No. You mean to say that you are not aware of this address? Yes, that is so. Do you know that one Dhruvo Narayan Guha? Yes. Who is he? He is the husband of my eldest paternal aunt. What is the name of your eldest paternal aunt? Srimati Guha. Do you know where Dhruvo Narayan Guha and Srimati Guha used to reside? No. You mean to say that you are not aware where your paternal aunt and your uncle reside? Is that so? We did not have quite that kind of relationship. He doesn't know their aunt and uncle's residence. I put it to you that Srimati Guha and Dhruvo Narayan Guha, your paternal aunt and uncle, reside at 27C Nimo Goswami Lane, Kolkata so and so. Will you be in a position to contradict me? I do not even know the address. So he doesn't say they don't. Do you recollect the incident of 13 December 1995? I cannot recollect the incident of 13 December 95. Do you know that your grandmother Shonamoni Shah had lodged a complaint with Jorbagan police station on 15 December 1995? No. Will you be able to contradict me if I tell you that on 13 December, your grandmother Shonamoni Shah was taken to a hospital for X-ray by an ambulance? I do not know. Was your grandmother Shonamoni Shah close to your paternal aunt and uncle, Srimati Guha? Yes, he admits. Will you contradict me if I tell you that on 13 December, after your grandmother left 13 Mandal Street by ambulance to get an X-ray, she went to 27C Nimo Goswami Lane to stay with her daughter Srimati Guha? I cannot agree because I do not know. So he doesn't disagree. Because the entire case is that this grandmother had come to my house, then shown a document with regard to this complaint which was filed on Jorbagan. Do you remember anything regarding this document? I do not know. Shown paragraph 4A of the plaint, the para which is in relation to me. On what basis have you made this statement? My younger paternal uncle, who was the defendant number 2, had sold off all the movable properties left by my paternal grandfather without our knowledge. He makes out the case here, but he has not proved that the goods belong to the paternal grandfather or that I have sold it. I am asking you that whatever you have said in para 4A of your plaint, what is the basis of such statement? The fact that my paternal grandfather had left such property were intimated to me and the plaintiff number 2, being the brother, and we came to know about them from our father, but we did not find these items. So it's all hearsay. We have come to know from my father. It is a hearsay evidence that the Schedule C, the goods in paragraph 4A, they were the grandfather's goods. That is hearsay.
Which para you refer to?
Question 4A, question 256. 256, shown para 4A of the plaint. On what basis have you made this statement? My younger paternal uncle, who was the defendant number 2, had sold off all the movable properties left by my paternal grandfather without our knowledge. Next question. I'm asking you that whatever you have said in para 4A of your plaint, what is the basis of such statement? The fact that my paternal grandfather had left such property were intimated to me. So he has heard it from someone, and the plaintiff number 2 being my brother.
Or father.
And we have come to know from our father. So he has no personal knowledge. And we do not find these items. Question repeated, another opportunity given. I don't think I should have given that opportunity. On what basis have you claimed that the defendant number 2 had sold these articles? Since we did not get accounts for such property, and since all such properties were with our paternal uncle, and he was the custodian of this property, being the executor of the will. It's a completely circuitous statement. It's surmise and conjecture. There is no proof that this has been made. Then now question 259. I suggested to you that you have no basis and no proof of making the statement in para 4A of the plaint of the defendant number 2 sold such articles. I do not agree. I suggested to you that you have no basis and no proof of making such statement in para 5 of the plaint. I do not agree. Whatever I have said is correct. I suggested to you that the statement made in para 6 of your plaint is also incorrect. Whatever I have said in the plaint is plaint paragraph is correct, so I do not agree. I suggested to you that Amal Saha never visited 13 Mandal Street in second week of...
Yes, according to you, but for this evidence, this piece of evidence, nothing is proved.
So neither has the plaintiff been able to discharge the burden of proof that the goods belong to the father or has been sold by me. So they can't claim any right over it. That's number one, para 4A. And second, Lordship will find there is no case of undue influence made out, apart from a vague allegation that the grandmother had come to my house when the property was being sold. And I apparently went on the day and said that the property has been sold. That's just an averment, an allegation. It's not proof of undue influence. That is all, my lord. So, my lord, so far as the case made out, and my lord, the reliefs as has been claimed against me, they've not been able to prove it. Only relief against me is, my lord, prayer D. And my lord, I have in my written statement, I have denied all these statements. I don't want to take your lordship.
All right.
These are my submissions.
You are for 2.
Defend number 1 now, although in the body of the plaint, reference is made as original defend number 2.
Heard Mr. Mukherjee, the learned counsel appearing for the present defendant number 1. Fix so and so for hearing argument of defendant number
3A to 3F. 3A to 3F.
3A to 3F. When will you be able to come? Six September. Whole shoot view tar hocche na. Whole shoot view tar ajke nahi. I have got back some of my old habits of hearing arguments.
No, your lordship has been, I have also.
Yes, you're regular coming.